Yes. I'm mentioning one matter for listing, my lord. It was picked on 8th of September. A criminal petition arising out of a maintenance proceeding by wife, my lord. By law, next week.
Give it to Purna.
Yes. Thank you.
Please, Your Lordship, listing of a criminal revision, Your Lordship, and a criminal petition both are tagged, Your Lordship. DB proceeding and maintenance is stayed, Your Lordship. Oblige, Your Lordship.
Step number 9, my lord. I'm appearing on the behalf of the petitioner, my lord. My friend, my lord, he appears on number 2, my lord. He has got some personal level. Can it be taken up in the next week, my lord?
Okay. Mr. P. Kotogi, Learned Counsel for the petitioner, has submitted that Mr. I.A. Hazarika, Learned Counsel, appearing for the respondent, has made a request to him to make a prayer for adjournment on his behalf. Okay, as sought for, I'll leave the case on next week.
Fine.
There is interim order may have come.
Interim order passed, I shall continue till then.
9th February.
9 February.
Daily list for motion, item number 1.
Big lordship, my lord. My lord, I preferred this transfer petition because in the matter connected to the NSGA case number 80/2025, which was filed against me under Section 130 of the Negotiable Instrument Act 1881, and which has been pending in the court of the Lance Museum, Serang, my lord. So, Lance Museum, Serang, my lord. Serang, my lord. And before arguing further, my lord, item number 2 is also similar, my lord. So my argument on this matter will cover up that item number 2 also, my lord. And now, my lord, I just want to take a lordship to page 27, Annexure 2, page 27, Annexure 2, my lord. I'm just reading out the relevant portion for lordship, kind convenience, my lord. Page 20, para 22, page 27. Moreover, since the main thrust of the petitioner is on the fact that the transaction in question was conducted in cash and being in excess of 20,000 cannot constitute legally enforceable debt in view of Section 269 SS of the Income Tax Act, it stands demolished by the decision of the Apex Court in Sanja by Tari Supra. I don't see any scope for in interference in exercise of powers under Section 528 BNSS. I preferred, my lord, for quashing of the case, my lord, which is deceased, my lord. Now I just want to take a lordship to Annex 3, page 28. Only because of this trust is my debt, my lord, I have shifted my residence to Guwahati, my lord, from Serang, where I originally stayed, my lord. Due to my various age or illness, my lord, these are all the documents which I have annexed carried for lordship's kind convenience. And he is almost 60 years old, my lord. For that matter, only for this reason, my lord, it is very difficult to travel to Serang, my lord, which is a very long distance for me, my lord. So that is why I have preferred this application before lordship. Since 2024, my lord, I have been staying here, taking various advices from doctors, my lord.
Who is the complaint?
Complaint is from Serang, my lord.
Who is the complaint?
Complaint is on, my lord, page 11, my lord. Page 11, my lord. I vouch, my lord, I will appear on each and every date that is will be given in this, if the lordship is highly satisfied, my lord.
The first petition is regarding which check? First complaint petition is regarding which check?
Regarding, my lord, check number, my lord, is 485249. There are six checks, my lord. The first one is
5249.
249, my lord.
And second petition?
Second petition. And to apply 9. Second petition. Second petition. Second number, sir. Basically, my lord, in 6 cases, my lord, Honorable High Court passed a common order in all the 6 cases, my lord. Second is, my lord, 485276.
Different complainant.
Different complaints, my lord.
Where the check was presented?
Check was presented, my lord,
Where check was presented?
at my lord, Sirang.
Hmm.
At
So
Sirang,
that-
my-
Court has only the territorial jurisdiction to try.
my lord.
That court
No,
has
after
the
my-
jurisdiction to try that offense under the NI Act.
No, my lord, I am not on
And
that.
your office, you are a contractor
My lord, my lord, my lord,
and you execute contracts
my lord,
in Bongaigaon,
my lord, my lord.
in IOCL,
Yes, my lord, my
with
lord,
IOCL, and they are subcontractors,
my lord.
one of them at least, subcontractors.
Your lordship is absolute.
So you have difficulty to appear in the court in Shirang, whereas you have no difficulty to carry out contract works in Bongaigaon.
No, my lord, I have stopped, my lord. Now I am partially, my lord, bedridden, my lord. Virtually since
Ah.
2024, my lord. I am not
You
carrying
make
out
an
any-
application for dispensing with your personal appearance.
my lord.
That court will try, decide that issue. Nowadays, Section 530B
My lord,
and
my lord.
SS.
That will do, my lord, that will do.
You make an application, 530B and SS is there. Everything can be done virtually if court
My
is
lord.
satisfied.
My lord, my lord.
We don't think so that your arraignment
My lord,
on every day is not necessary.
my lord, absolutely good.
We don't find
Obliged,
any
ma'am.
merit.
Obliged,
Therefore,
ma'am,
first you
obliged.
make an application for
Obliged, ma'am.
under section 530. Because all these provisions can be followed now.
My lord.
530.
What are these? Yes, yes.
530. B and SS. So far as transfer is concerned, we find no merit.
My lord.
Enact territorial jurisdiction is clear. Right.
My lord.
And so far as exemption from personal appearance is concerned, you have to make a prayer before the court. Because evidence of the witnesses, evidence of the accused, all can be recorded audio visually
My lord.
through video conference as per the rules.
My lord. My lord.
Section 530 is there. We have Guwahati High Court rules district.
My lord. My lord.
If you have only at the stage of maybe 313, I don't know, that also can be permitted.
My lord.
You can plead guilty also through video conference.
My
We
lord.
find no, you make an application before the court.
My
If that disallows your personal appearance, then only you can come. Otherwise, we find no ground in transfer proceeding. Here it is fair. We can only observe that you make an application because
My
everything
that
can
will
be
do.
done.
That will do. My lord.
That has been the same. Heard Mr. S.
My
Rahman,
lord. I am SSA Rahman. He is
S.S.A. Rahman,
my lord.
learned counsel for the petitioners. Petition. Full stop. As the subject matter of both the criminal petitions, both the transfer petitions, within bracket criminal, there's criminal transfer petition criminal number 1/2025. 26 and transfer criminal number size 2 are preferred on similar grounds by the same petitioner. Commando, the respondents arrayed are different, comma, both the transfer petitions are taken up for consideration at the motion stage itself, having regard to the grounds ours for transfer of the two complaint cases, comma, NICR case number 8 of 2025 and complaint case within bracket NJ case number 03 of 2025, comma, presently pending before a court of where they are pending.
My lord. Pending in the court of the land season Serang, my lord.
Where are the summons?
Summons is that my lord page. Page 10, my lord.
Page 10. Before the court of learned Chief Judicial Magistrate
Serang, my lord.
Sirang, within bracket trial court for short, full stop. Para. In the complaint is, NICR case number 8/2025. A Bridgestone বলে একটা আছে, Bridgestone, the one Muhammad Qurban Ali has instituted a complaint against the petitioner as the sole accused, alleging under Section 138 of the Negotiable Instrument Act 1881 as amended, alleging dishonor of 3/6 issued by the petitioner accused as a drawer of the sick from an account maintained from a savings bank account maintained at Dhaligaon branch, BRPL complex of the State Bank of India. Full stop. The complainant has alleged that when the checks were presented for collection, in his savings bank account maintained at Dhaligaon branch BRPL complex, state of the State Bank of India, the checks were dishonored or returned unpaid on the ground of insufficiency of fund in the account of the petitioner accused. Full stop. After taking cognizance on the complaint, the trial court has already issued process against the petitioner for his appearance before the trial court. Full stop. The criminal petition, the transfer petition number 1 of 2026 has been preferred, seeking transfer of the proceedings of NICR case number 8/2025 from the Court of Law and Chief Judicial Magistrate, Kamrup, Chirang, to the Court of Learned Chief Judicial Magistrate, Kamrup Metro. Full stop. 1. Abu Basir Rejaul Haq Ahmed has instituted the other complaint case, complaint case NI number 03/2025 before the trial court on the ground in connection with a check issued for an amount of rupees 10 lakh by the petitioner in the favor of the complainant from the same savings bank account maintained at Haligaon branch, comma, BRPL complex of the State Bank of India. Post. It is ever in the complaint when the check was presented by the complainant in his bank account maintained at Thaligaon branch BRPL complex. No, BRPL complex branch, Thaligaon of the State Bank of India. The check was returned unpaid on the ground of insufficiency of fund in the savings bank account of the petitioner accused. Full stop. The complainant thereafter, after observance of due proceed formalities, instituted a complaint under Section 138 of the Negotiable Instrument Act and the trial court, upon taking cognizance of the offense, he should process within bracket summons to the petitioner accused for his appearance before the trial court. Full stop. Para. In both the complaints, the complainants, in a concern, presented the checks, issued by the petitioner accused, in their respective bank accounts maintained at BRPL complex branch, Thaligaon of the State Bank of India. Full stop. As per subclause A of subsection 2 of section 142 of the Negotiable Instruments Act 1881 as amended, the offense under section 138 shall be inquired into and tried only by a court within whose local jurisdiction, if the check is delivered for collection through an account, the branch of the bank where the payee or holder in due course, as the case may be, maintains the account, is situated. Full stop. Having regard to the said statutory provision, the Honorable Supreme Court in Bridgestone India Private Limited versus Inderpal Singh, 2016 to SCC 75, has observed that section 142 2A, amended to the negotiable instruments within bracket amendment of the Negotiable Instrument Act 1881 as amended has vested jurisdiction for initiating proceedings for the offense under Section 138 of the Negotiable Instrument Act, inter alia in the territorial jurisdiction of the court, where the check is delivered for collection, within bracket, through an account of the branch of the bank, where the payee or holder in due course maintains an account, bracket close, full stop. Para. Para. Therefore, the Court of London Chief Judicial Magistrate, Chirang, has definitely has the territorial jurisdiction to try the offense under Section 138 Negotiation Act as alleged in the two complaints. Full stop. Para. The grounds urged by the petitioner in the two criminal petitions is that the petitioner the petitioner has his ancestral house at Chirang, but as he is having as he has started experiencing serious health issues requiring regular medical treatment, he has shifted his base to Guwahati since July 2024. And since then, the petitioner is residing at Guwahati. Full stop. Due to institution or two complaint cases before a trial court at Chirang, the petitioner, who is aged about 60 years, would face inconvenience to appear before the trial court by traveling the distance from Guwahati to Chirang. Full stop. Para. It has emerged from the record that at an earlier point of time, the petitioner instituted criminal petitions before under Section 528 Bharatiya Nagarik Suraksha Honita 2023, seeking quashing of the criminal proceedings of NICR case number 03/2025 and NICR case number 8/2025. This court, after considering the grounds urged on behalf of the petitioner therein, that is petitioner, dismissed the criminal petitions, criminal petition number 641/2025 and criminal petition number 528/2025 Silver number respectively by judgments on 2/12/2025. It is after dismissal of the criminal petitions, state criminal petitions. These two criminal transfer petitions have been preferred. Full stop. Though it is urged in the complaint of NICR case number 03/2025, the complainant has asserted that the petitioner herein is a contractor who undertakes contract works at Bongaigaon Refinery Indian Oil Corporation Limited IOCL, and the complainant is a subcontractor under the petitioner. Full stop. It is in connection with a contract work issued in favor of the petitioner by the Bongaigaon Refinery IOCL. The petitioner borrowed a sum from the complainant, and in order to and against such borrowing, the check which later on to dishonored was issued. Full stop. Para. These two transfer petitions are preferred under section 447 BNSS, stating that on the grounds mentioned above. Full stop. Para. Section 447 of the BNSS has provided that the High Court has the power to transfer cases and appeals. Full stop. For ready reference, subsection 1 of section 447 is quoted hereunder. Para. On a reading of the provisions contained in subsection 1 of section 447 of the BNSS, it is evident that the power to transfer cases is exercisable in three situations. A, that a fair and impartial inquiry or trial cannot be had in any criminal court subordinate thereto, or that some questions of law of unusual difficulty is likely to arise, or C, that an order under this section is required by any provisions of this Sanhita or will tend to the general convenience of the parties or witnesses, or is expedient for the ends of justice, it may order. Roman 1, 2, 3, 4. In Rajiv Talwar versus CBI, Rajesh Talwar, 2012, 4 SSC, comma, para, the Honorable Supreme Court has observed in the following words, para 46, jurisdiction of a court to conduct criminal prosecution is based on the provisions of the Code of Criminal Procedure. Often either the complainant or the accused have to travel across an entire state to attend to criminal proceedings before a jurisdictional court. In some cases, to reach the venue of the trial court, comma, a complainant or an accused may have to travel across several states. Likewise, comma, witnesses too may also have to travel long distance in order to depose before the jurisdictional court, full stop. If the plea of inconvenience for transferring the cases from one court to another, comma, on the basis of time taken to travel to the court conducting the criminal trial is accepted, comma, the provisions contained in the Criminal Procedure Code earmarking the courts having jurisdiction to try cases would be rendered meaningless. Full stop. Convenience or inconvenience are inconsequential so far as the mandate of law is concerned. Full stop. The instant plea, comma, therefore, comma, deserves outright rejection. Full stop. Para. The petitioner's plea herein for transfer is based primarily on inconvenience and the distance to travel. Full stop. The distance. How much is the distance from Guwahati? The distance from Guwahati to Chirang is stated to be about 160 kilometer. About, I said. I said about is less than 170 kilometer. Full stop. Para. Now, power under section 407. CRPC has to be construed strictly and is to be exercised sparingly and with great circumspection. Full stop. The power to transfer, the power to the discretion of transferring cases is to be exercised only when it will be expedient for the ends of justice. Full stop. And in the cases in hand, comma, such factors are found to be absent. Full stop. Para. If the petitioner has any experience with petitioner, it is always available to the petitioner to seek exemption from personal appearance and to appear in the proceedings. Also true. Yes. Also true. Electronic mode, full stop, as per section 530 BNSS, comma, all trials, comma, inquiries and proceedings under this Sanhita, including 1, 2, 3, 4, may be held in electronic mode, comma, by use of electronic communication or use of audio-visual electronic means. Full stop. the Guwahati High Court, in order to avoid delay in judicial proceeding due to non-availability of parties, advocates, witnesses, and accused physically, has framed the Guwahati High Court use of electronic communication and audio-visual electronic means rules within bracket Naya Shruti, 2025 to formalize and enable use of electronic communication and other audio-visual electronic means for the purpose of conducting trial, inquiry and proceeding under the BNSS. Full stop. The BNSS under section 54 pa likhi dibo, 530 recognizes use of audio-visual electronic means and other forms of electronic communication for different proceedings. Full stop. Which includes which permits electronic hearings, recording of evidence, including evidence of witnesses, etc. Full stop. On a query made by this court to the Learned Counsel for the petitioner, the Learned Counsel for the petitioner has fairly submitted that the petition has not exercised and has not preferred any petition seeking exemption for personal appearance before the trial court, has neither preferred any application seeking exemption from personal appearance or to permit him to appear through audio visual conference mode. Full stop. In till date, in such view of the matter, liberty stands reserved to the petitioner to seek personal exemption as well as to appear through audio. Stands reserved to prefer an application either to seek exemption for personal appearance or from or to appear through audio visual audio video electronic means, except on the occasion where his personal appearance is necessary.
My lord.
Full stop. With the above observations, full stop. The criminal disorder because of the writ petition or criminal petitions, both the transfer petitions.
Highly obliged, my lord. Highly obliged.
Item 3,
Bad resolution.
Yes.
My lord, here, my lord, background of this case is that, my lord. Background of this case is that petitioner before your lordship, once she filed one complaint case, my lord. Thereafter, this complaint.
Where is the complaint case?
First annexure, my lord, it is page 13, my lord.
Okay, page 13. When you file?
My lord, it is filed 2021, my lord.
Hmm.
It is, my lord, then, my lord, immediately court passed order to investigate the matter, page 21, my lord.
Page 21.
It was
What was
provided.
the allegation?
Allegation,
T76E.
Yes, my lord.
Against how many person? Nazrul Asraful Soljana.
Yes.
Okay.
Then, my lord, but police did not take step in this matter. Therefore, she filed one complaint also, my lord. This is page 22,
2.
annexure 3. Thereafter, my lord, in the meantime, long time elapsed, my lord. After more than, my lord, 1.5 year, my lord, she was medically examined, my lord, page 25, my lord.
2020.
case was lodged, my lord, 23/4/2021. Medical was conducted after complaining on 19/10.
Just a minute. Spiritual treatment.
Yes, ma'am.
Huh?
Yes, ma'am. Then medical was conducted.
When it was registered, when this,
My lord, case was registered a long time later, 1.5
Uh-huh.
year, my lord. This is, my lord, date, page, my lord, 16 in their form, my lord.
page 16,
Yes, my lord.
occurrence, information. You file it before magistrate court.
Magistrate court, my lord. Magistrate sent, my lord. Then it was registered, my lord, page 20 on, my lord, 7/10/2022, my lord.
710. When magistrate sent it?
Magistrate, my lord, it is sent immediately thereafter. This is page 21, my lord. 28/4/2021, it was sent by the magistrate.
156.3.
Yes, ma'am.
Send a complaint. Congratulations.
Then,
Register a case. So 710,
yes, my lord.
2022.
Yes, my lord.
Okay, then you prefer this one.
Then, my lord,
Case 22 petition.
then medical done, my lord, and my lord,
Medical done.
yes, my lord. Because they are, my lord, otherwise, my lord, related, my lord.
Okay.
Actually,
Okay.
both the families are relative each other, my lord. Then, in the meantime, my lord, they approach with elderly people, and matter was, my lord, amicably settled. Accordingly, she, my lord, made statement before the magistrate, my lord, page 27, annexure 5. It was magistrate, my lord.
How your pregnancy resulted in any birth? Your pregnancy?
No, my lord.
My lord, this is additional affidavit. I am sorry, my lord. Additional affidavit, my lord, bringing on records, my lord. I'm sorry, my lord. Page number 100.
There is no 100. Okay, 100. Second, how many affidavit you have filed?
The two affidavits, my lord. Because subsequently, when the notice to the legal heirs were submitted,
No
served, my lord.
100. What 100 parliament? Which affidavits?
My lord, affidavit dated, my lord, 25th day of March 2025, my lord.
25th. Find out. Your
Yes. Yes, ma'am.
If the original, otherwise common sense says if the original proceeding is not there,
My lord,
it is closed.
my lord.
Another proceeding which is based on the original proceeding, it
Right.
cannot survive.
Because my plea is that, my lord,
No, that if anything is to be recovered from the pension,
my lord.
that you should have moved a petition before the original court.
But the calculation as made in the final order, my lord.
We are
That is
not
done.
calculating, we are not executing, sir.
No, my lord, that is done from, based on the order dated, my lord, 5/8/2023, That is from the order of the date of the order.
What 125 says further, 126 to 127, what's those proceedings says?
My lord.
See, one proceeding, original proceeding, it is not, it is closed already.
My lord.
The proceeding before this court, which is based on the original proceeding, cannot survive.
But that will not,
If
when
the-
I
if the-
challenge this,
if the- if the- suppose,
My lord.
if the original suit is not there,
my lord,
how can an appeal or revision preferred against some order passed in that original suit can survive before the higher forum?
because my lord, when I preferred this proceeding, my lord, by that time the husband
Oh,
was alive.
Mr. Counsel,
Because until and unless that order is modified or it.
that order, you came against an order of interim maintenance.
My lord,
Right.
my lord,
But by virtue of the final order, that original proceeding is closed.
my lord.
Right, because of the death.
Yes, my lord,
Considering the fact that the person was a government
my lord,
pensioner,
my lord.
you could have raised that interim area, maintenance area,
My lord,
in while closing that, you should have preferred a petition there.
my lord,
Right. You did not do so.
my lord. Because,
You allowed the proceeding to close.
because in the meantime.
How can,
My lord, I
how
understand.
can this proceeding can survive?
Because so far as the interim is concerned, that is my understanding, my lord, subject to my lordship
See page,
approval.
section 128.
Well.
128 of chapter 9.
My lord,
Enforcement of order of maintenance.
Well.
A copy of the order of maintenance or interim maintenance
my lord,
and expenses of proceeding as the case may be shall be given without payment to the person in whose favor it is made, or to his guardian, if any, or to the person to whom the allowance for maintenance or allowance for interim maintenance and expenses of proceeding as the case may be is to be paid. And such order may be enforced by any magistrate
my lord.
in any place.
But that in that case, my lord, my entitlement would be, my lord, as per the calculation from the date of the order, my lord.
You have not understood my point. When original proceeding is closed, right?
My lord,
In a case,
my lord.
when appeal is suppose allowed or dismissed,
Right.
any miscase will survive thereafter.
But in
And if the original suit is closed, any appeal can be dismissed
that
or
cannot
whatever.
be-
Where is the order?
that
Find
cannot-
out the
Yes.
order. You should have moved a petition under section 128 CRPC for enforcement of the order of area interim maintenance. And that magistrate court or family court could have initiated proceedings for recovery from the pension amount or whatever,
but in that
terminal benefits of the deceased.
the executive court, my lord, cannot.
Disease, because these two cannot be.
Because if I prefer an application before the learned family court, my lord,
Have
The
you
executive-
understood? If the original proceeding is closed, how can this survive? Find out the order.
my lord, actually, the additional affidavit by bringing on record, my lord, the order, it is not here, my lord, on record.
It is also not on record.
But that, my lord, the
Where
order
is the
is
order
passed,
passed? Let us
IA
read
is
it.
disposed of, my lord.
But IA, whatever proceeding cannot proceed
My lord.
against the law.
But my understanding is that, my lord. So I understand that, your lordship is absolutely correct, my lord. But an executive court
If
cannot
I am
enhance, my
correct,
lord.
then how can this
But
proceed?
my understanding is that, my lord,
Proceeding go on.
if I file an execution proceeding, my lord, the executing court cannot modify or enhance my, my lord, entitlement. If I am entitled to, my lord, from the date of filing of the application, my lord, that was my understanding,
If
That-
you're governed by Muslim law,
my lord.
I think division bench has clarified now you can have your half of pension,
My lord,
either first wife or second wife, whatever, law is governed,
my lord.
right?
But
By division bench, it has been settled because it was a very complicated issue. Now division bench has settled it. Now the law is settled that second wife can also have a pie
my lord,
from the pension
my lord.
of the deceased. So one option is available for you, though I am not here to make
No, my
advice.
lord, so far as the, my lord, one judgment I relied upon before the learned court, my lord. That is, my lord.
No, you have not understood the question when the original proceeding is not there.
my apprehension is that, my lord, if I file the execution proceeding, I would be entitled to the amount and it would be
Right.
from the order.
When in a date proceeding, how can we enhance it?
Because
Just because there is violation of Rajneesh.
my lord,
Have you understood?
because I filed this proceeding when my
We
husband was
cannot,
alive,
it is a purely interim order,
my lord.
right?
Mm.
It is an interim order. Interim order survives till the final order.
My lord,
If the final order is closure of the proceeding,
my lord.
how can we review or revise that order, interim order? Who is the order of closure?
My lord, yes. Order is at, my lord,
Because 125 does not allow
my lord. May I read
for
that?
the, from recovery
My lord.
from the
Date of,
son of the first wife or second wife or the second from the second wife.
my lord.
It is through the, from the pension you can recover.
But to that effect, one judgment is there.
So, show me the closure report, sir, first.
My lord. May I permit to read it?
Yes, please, hand over, hand it to. Is it part of the case record?
But in the original file, it is not. there.
Not there.
But in that case, my lord,
How can we?
IA 655 that has, there are several orders on IA 655 of 2025, my lord. Order has been passed and that IA has been disposed of, my lord.
IA has been disposed of simply by impleading the son and the first wife or second wife,
My lord,
right?
my lord,
It has not decided on the merits.
my lord.
You
And so
made a
far as-
prayer,
My lord,
court has impleaded without observing anything on merit.
my lord. And so far as my additional affidavit, my lord, it was filed immediately after the demise of the his husband. MP order আছে আপনার 54 main case, 54 case number.
No, correctly, what I have observed.
Right.
See, Mr. Counsel, you have not made this order a part of the case record. Court has said opposite party expired,
My lord,
but before his date, opposite party failed to comply with the order of maintenance,
my lord,
so directed by the court. As such, area maintenance of rupees 1,50,000 has accumulated, right?
Right.
Then court has proceeded that 144, whatever, praying for issuance, 144 is, I think, equivalent to 128 perhaps.
my lord, my lord,
Is it not?
my lord.
Ah.
144.
Then court said that you prayed for issuance of warrant to the drawing and disbursing officer,
My lord,
Clum Block Elementary Education Officer to realize, recover the area maintenance,
my lord,
right?
my lord,
Then you relied upon Punjab and Haryana.
my lord.
Then court has observed the petitioner is entitled to get her area maintenance allowance either from the pensionary benefits of the opposite party or from his movable properties. So this proceeding execution section of the office is directed to register an execution case. So execution case must be pending.
No, my lord, that was not filed, my lord. Because
Then-
this proceeding was pending.
Then you are wasting time. It is evidently clear.
To that extent, that is clear. but-
Rajneesh cannot be gone into.
My lord,
That is luck.
that was my perception, my lord, that if that.
No, if the original proceeding is not surviving, it is closed,
My lord,
it gets merged into the final order.
Right.
And if you want to challenge the final order, that is a different issue.
Right.
But without the presence of the person,
my lord,
it is only option is to recover it from the pension. And plus, you can have a share from the pension as per the settled law. by filing a writ petition
My lord.
for till your survival.
Right.
That is for you.
Actually,
This part you have to,
my lord. Actually, I was under that perception that if the interim order is modified, then in that case,
no
I
interim
can
order
claim.
which is not, you have
Right.
already merged with the final order.
My
You cannot reopen it.
lord.
Either you have to challenge the final order,
My lord.
but that will be also will result
Okay,
into
my lord.
nothing.
My lord. I'll go there and then file the.
You
application.
first execute
My lord.
this order
My
and you can have a share from the pension
lord.
as you are governed by Muslim law.
My lord.
By, you know,
I'll do my.
you are a seasoned counsel.
My lord. I'll do my.
We'll close it without
My-
on your heart.
Only observation that my lord, since I have not made any execution proceeding, and that is to be done within 1 year. So that has already gone, my lord. So that to that effect.
That I'll not say.
My lord.
That I will not say. It was passed in which date?
My lord, the interim order was passed on 5/8/2023.
No, the final order.
The final 6/1/25, my lord.
6/1/2025. And what is the time limit? Is there
1
any
year.
time limit?
1 year, my lord.
Huh?
1 year.
128? 128?
Yes, but.
I don't know, but in civil, I think more. But Mr.
ALE.
A. Ali, learned counsel for the petitioner. Ms. Bora, you were there.
Lordship.
And who is for the private respondent?
They have not appeared.
Not appearing.
They know that no order can be passed against them.
Lordship. Order way also, Lordship, criminal revision does not lie against an interlocutory order, Lordship. That is also not mentioned.
Ms. S.H. Vora, learned additional public prosecutor for the respondent state. Post of this criminal revision petition is preferred against an order dated 5/8/2023 of under section 397. Read with section 401, Code of Criminal Procedure. Read with Article 227 of the Constitution will get is preferred, seeking modification of an order dated 5/8/2023 passed by the Court of Learned Principal Judge Family Court Kamloops Metro in FC within bracket CRL case number 698/2019. Full stop. By the order. The petitioner had preferred an application under section 125 CRPC, related with section 7 of the Family Courts Act 1984, seeking maintenance from her husband, Aksed Ali, AKSED Ali, full stop, by the order dated 5/8/2023, the Learned Family Court directed the opposite party therein, that is, Aksed Ali, to pay a sum of rupees 10,000 per month as interim maintenance from the date of the said order. Full stop. Aggrieved by the fact that the order for interim maintenance was made effective from the date of the order 5/8/2023 instead of the date of the application. The petitioner had preferred the present criminal revision petition. Full stop. During the pendency of the present criminal petition, Aksed Ali expired on when
4/11/2024, my lord.
4/11/24.
2024.
Full stop. Thereafter, the petitioner has brought the respondent number 2, respondent number 3 and
3 and
4
4, my lord.
on record as the legal representative of the respondent number 2, Aksid Ali. Full stop. The respondent number 3 and 4 are the
wife and the son respectively from the second marriage.
are the wife and the son of was the first or second?
Now she'll be first, my lord.
Okay. Were the first
Wife
wife
and
of Aksid Ali and her son. Full stop. Para, as when the matter of death, the demise of Aksid Ali was brought to the notice of the Learned Family Court, the Learned Family Court on 6/8/2025, has closed the proceedings of FC within bracket CRL case number 698/2019. Full stop. While closing the proceedings of FC so and so, the Learned Family Court had taken note of the fact that during his lifetime, Aksid Ali did not comply with the order of interim maintenance
Right.
passed on 5/8/2023,
23.
and as a result, an amount of rupees 1,50,000 had accumulated as area interim maintenance allowance. Full stop. The Learned Family Court had observed that the petitioner would be entitled to get her area maintenance allowance either from the pensionary benefits of Aksid Ali, as he was a government servant,
7.
or from the movable properties of Aksid Ali. Full stop. Para Mr. Ali, full stop. Since the original the proceedings of FC criminal case number 698/2019 has been closed on 6/1/2025, the present criminal revision petition, which arose out of the proceedings of FC so and so case number cannot survive. Full stop. It is therefore closed. Full stop. Insofar as the submission of the petitioner regarding area maintenance is concerned, the petitioner is at liberty to file an execution petition. Full stop. It has been observed by the Learned Family Court that by the order dated 6/8/2025, the Family Court had already directed to register an execution case by bringing the legal heirs of Aksid Ali on record and to issue notice to them for payment of the area maintenance allowance. Full stop. It is therefore, the petition is therefore entitled to pursue the execution proceedings is therefore entitled to take part in the execution proceedings directed to be initiated in terms of the order dated 6/1/2020. Court had already directed, there is no question or limitation.
My lord. Actually,
Court had directed to,
that I would be covered by Rajneesh, my lord, persuaded me to appear before this.
okay,
I'm obliged.
Item 8,
it was an order to copy, a copy of the order dated 6/10/2000. You give a copy of this order
My,
passed by the Family Court in FC, criminal case number so and so, 698/2019 is kept with the case record by marking it as X.
my lord, this is 482 application, my lord. For questioning of the charge sheet. My lord, on the last occasion, my lord, the statement recorded under 161 has been called for. That is not on record, my lord.
That is on
Record.
record. Case there is there.
Yes, there it was. It's still in front of me.
Like, case there is enough.
My lord, case diary is there, my lord. On the last occasion, the statement recorded under 161 was called for, my lord.
Call for the complete TCR along with statements for proper adjudication of the case. Case records as called for has not been received.
My lord, the case diary is there. So case diary 160.
Legible,
Yes, it is there.
legible.
I don't know, my lord. I have not seen it, my lord.
Otherwise, we will make you to read.
Okay, my
I
lord.
not read.
I'll assist the court, my lord.
Yeah, আছে? নাই দেখোন।
Case diary is there.
Where is it? Find out. I have not seen it.
And the cause list also shows, my lord.
I have not
That
seen
that
it.
is already there, my lord. Case diary is
Yeah,
there.
definitely.
The statements are not there, my lord.
Oh, I don't know. Case diary.
I have not seen the statements. After a cursory look.
My lord, here is a case wherein they have come for quashing. With regard to a case wherein charge sheet has been submitted, cognizance has been taken. Now, while preferring this petition, they ought to have brought on record all the 161 statement and everything. They have
No,
not.
after that order, what that order? That scan copy should be called for. So everybody,
My lord.
what is the case?
My lord, this is regarding, my lord, purchase of PP kit, my lord, during the COVID pandemic.
Criminal
Acha.
petition.
Case diary got good. Case diary got nine, huh?
Office note say it has not been received.
Oh,
That is not there.
not there, but here, sorry, here it is not there. Right?
We'll call for them.
Yes, the case
But
diary will, yes.
Mr. K. Sinha, learned counsel for the petitioner. Ms. S.H. Bora, learned additional public prosecutor for the respondent number 1. Mr. A.K. Bhuiya, learned counsel for the respondent number 2. Full stop. Issue a reminder for the complete TCR, along with the statements recorded under section 161 CRPC. তার আগত লিখিব। Peruse the office notated 21/1/2026. So, issue a reminder. Yes, list the case on. It is from which place?
Guwahati, my lord, Guwahati.
That's convenient date, February yoke.
And
We-
interim till the
Pastor.
next date, my lord.
Till the next date of list.
Obliged, my lord.
9th February.
9th February.
My lord, after 12, my lord, because.
Okay, after 12.
12.
18 to.
18.
Obliged.
Obliged.
Item number 10.
May it please, Lords.
Yes.
It's your petition. I'm saying it's your petition, you have to.
I'll definitely say it. My lord, it is a matter passing of the charge sheet. But basically on two grounds, maybe. Two grounds. One is that, the charge sheet has been filed. My lord, under section 173A, I'll come to that section, They say that the police can make further investigation. Now, further investigation has been, that section has been interpreted by the Supreme Court in several cases from 1979. I'll refer to that. Now, it says that firstly, that the permission of the magistrate has to be taken. Only because the power has been given in a 173(8) to the police to further investigate, they cannot do it without the permission. This is number one. Number two, in this case, when the first charge sheet was filed, trial has already begun. Against Partho Bhardwaj, the charge sheet has been filed, first charge sheet, and against him, the charge has already been filed, and the second charge sheet has been filed in December 2024. Now, third charge sheet has also been filed. Now, thirdly, that it says that to find out the new materials, because the further investigation has to find out that if any new material has been found out or not. But also from the materials on record that nothing has been found out new. Last statement was recorded in 19/7/2024. Our charge sheet was first charge sheet was filed on 24/7/2024, and the second charge sheet against us was filed in December 2024. This is first point. The second aspect, that I have said that, reading everything, all the materials they have collected against us. No case has been made out against us. That is second case, Or the basic case is against Partha Bhardwaj. If at all something has been done, he has done, he has cheated, he had made forgery,
Where is the FIR?
I'll come to that. Page 89, My lord can directly come to page 94, my lord. May I read, my lord? ध्यान रखना वो जो तुम्हारे कथा में जो डिस्कस किया था नोट नोट करके रखो डिस्कस किया था तो ये है ठीक है वो जो स्टेट क्या ना आप रिमोट करो
Okay. I read the complaint. Then charge sheet submitted.
Charge sheet submitted, my lord, here, my lord, your lordship will find the first charge sheet was submitted, or my lord, 20th of, my lord, in July 2024. Your lordship will find annexure 16, my lord.
Annexure 16.
16, page 329.
Charge sheet is annexure 5, my lords.
Huh?
My lords, it's annexure 5, my lords, the charge sheet, which is at page 100
Oh,
and-
I'm sorry, I'm sorry.
109, my lords.
I'm sorry, my lord. I'm actually.
109, my lord.
109, I'm sorry. I was just showing the bail order. 109.
Against how many?
Against
Only one, my
Only
lords.
Partha Bharadwaj. My lord, you will find the name.
Partha Bharadwaj.
My lord, he is the basic, my lord, main person, my lord.
That's the defense, my lords.
Your
Where is
lordship
the
will find
end
in
of it?
page,
Where is
page
the end
100
of it?
114, if your lordship kindly come to 114.
Where is the end?
My lord, page 114, if your lordship see, Partha Bharadwaj.
114.
Partha Bharadwaj. Then, my lord,
114.
yes. एक minute.
114. Then position.
My lord, may I just pinpoint to my lord,
Uh,
page 136 also, 100 page 136 also at the same time. May I take your lordship?
uh,
My lord, this, in course of investigation of the case,
right.
it has been proved that alleged Partha Bharadwaj, so and so and so and so, Chandmari, was appointed as advisor of Matak Automobile Council by the existing council headed by David Chetia, Chief Executive Council, MSc, illegally without approval of the government of Assam, who prepared false documents using seal, stamps, councils, and thereby ordered for supply of articles of so and so and so and so. Well, he was appointed. It's not that the appointment was. The appointment was not challenged, my lord. The persons who appointed, my lord, they are not accused in this case. By virtue of, my lord, their appointment, he, my lord, started, my lord, calling the persons so that he can give the supply orders and all that. One of the prosecution witnesses, my lord, he has supported this statement regarding his appointment and all.
In page 137,
137.
16.11,
Huh.
further investigation.
Yes, my lord, I have
Found
seen
that
it. I have seen
meaning,
it.
huh?
I have seen it.
Huh.
I have seen, my lord, that there, prayer was there, my lord. Prayer was there.
Will you come back then?
Yes. Prayer was there, my lord. That aspect is it. Not 137, my lord has seen. Yeah. 137, as my lord pointed out, that there was a prayer from the investigating officer. The lordship will find that further investigation has been found that remaining FIR named accused persons and other accused persons are required, which is now under process. Some of the accused persons are yet to be arrested. Under the above fact circumstances, prayer is submitted before the Honorable Court to accept the charge sheet submitted against the above mentioned accused persons with the prayer to allow to continue the further investigation against the remaining FIR accused persons and others to conclude the investigation. Now, my lord, on this prayer, well, there is no order. I'll come to that. Then, my lord, the charge sheet filed against us. 173. Yeah. तुम्हारा कुछ समझता ही नहीं है तुम बात को.
Yes.
173, 8 my lord does not say that the permission is required.
Hmm.
But judicial decisions are there, my lord, also, my lord. I have seen it. The only thing they say here, my lord, that there must be discovery of fresh materials. That your lordship will find officer in charge of the police station obtains further evidence, oral or documentary. He shall forward to the magistrate a further report or reports regarding such evidence in the form of prescribed. Now, my lord, may I take my lord to the second charge sheet, which
Hmm.
is filed against us, is 151, my lord. I'm sorry, my lord. At
39.
page 139.
139.
144.
139, my lord. That was dated 13/12/2024. Under section 120B, 417, 419, 420, 406, 465, 467, 471. Now, my lord, the same thing. Now, in this, they have relied on your lordship will find page 144.
Yes.
Kuruppan Nagappan. He is not the petitioner before. The next, my lord, will find next page 145. Bheluppu Srinivasalu.
Hmm.
145. Now, then go to page 146.
Hmm.
My lord will find these are the witnesses they are relying on, 13.
These are additional witnesses?
Now, these are not additional, my lord. I have given a chart, my lord. I'll give it to my lord, my lord. They have been already there in this, my lord. Except one probably. Raja, Inspector Raja. I prepared a chart to that, my lord. My lord, your lordship, my lord, earlier scan copy was called for. Only the statement has been furnished, my lord. Document has not been furnished to this court. Now,
That is procedural.
my lord?
That is procedural part.
No. I'm not saying that, my lord. My lord, lordship called for the, my lord, scan copy. So far, the, my lord, statements they have furnished, my lord, scan copy. So far, the other documents which are being relied on, my lord, those copies has not been given here, my lord.
To the accused?
No, my lord, before the
In
court.
the record.
My lord, I'll get, my lord, it is a procedure.
Ah.
I'll once appear, then, my lord, the procedure will follow.
Yes.
And if any grievance, my lord, I can raise there. Now, your lordship will kindly see the documents also in the same page, page 147.
Hmm.
There are 7 documents. Basically, there are several documents, but they have given some documents in one year, serial number, FIR, then certificate of registration, original letter of award, original letter of memorandum, all these, my lord. Basically, nothing to do with us, my lord. These are all issued by, my lord, Partha Bharadwaj. Then, my lord, there are A-way bill, my lord. They have also supplied goods, my lord. Having received the year, they have supplied goods. They got some money also. And, my lord, they have paid some, my lord, percentage to Mr. Partha Bharadwaj. Then sketch map certificate under section 65 of the telephone, along with the CDR DVD copies, CDR DVD copies, CDR DVD. This is bank statement. And, my lord, the content of this, my lord, the charge sheet from page, my lord, page 151 is, my lord, basically exactly the same what has been in the first charge sheet. A replica of, my lord, the FIR, practically. So it ends at page 165.
Yes.
My lord, basically whatever is stated in the FIR, my lord, the same thing is there, my lord. Whatever is there against us also in the FIR, that is here, my lord. Now, if your lordship will kindly come to now page 334. I'm just showing my lord the orders. 29/7/2024. 334, my lord. I just check it also. Huh? Lecture 17, page 334. Case record received contain, this is regarding first charge sheet, my lord. Put up, seen the charge sheet submitted by you against the parcel so and so and so, and enclosing two sketch map for so and so and so, so and so and so and so. However, original CD is not forwarded with PS, call for the same. Case is made over to self. The next order, my lord, is practically same. CR received. Well, this process on perusal of the entire record after single and APP accepted, the record shows that accused in judicial custody in view of the materials available before me, cognizance is taken. Now, the next order, my lord will find at page 336. Copy is ready and same is furnished, my lord, in middle. Order dated 30/8/2024. Copy is ready and same is furnished to the accused person. That, my lord, to Partho Bhardwaj. Then my lord can turn to next page, page 337. Mary University, 25/9/2024. I'm not reading last, considering the materials available on record and after hearing both the sides, it appears that a prima facie case under section so and so is made out against the accused. Accordingly, charge under section so and so is framed, read over and explained. And accused Partho Bhardwaj, to which he pleaded not guilty and claimed to be tried. Now, on 3/1/2025, after filing the, my lord, the second charge sheet, my lord, the order was passed on 3/1/2025. Additional charge sheet along with the documents in continuation of CID PS case number has been submitted by you against so and so. Accordingly, cognizance of offence under section so and so have been taken against the accused person so and so and so and so. Issue summons to so and so, fix itna for protection of accused Partho Bhardwaj. Rest are not important, my lord, beside the matter. Now, my lord, in the meantime, third charge sheet has also been filed, which is not on record, my lord. I have not brought the charge sheet. That was filed, I think, my lord, on 29th of July 2025. The order sheet is with me, my lord, not there, my lord. Conclusive charge sheet is put up. May I read, my lord?
Yes.
This is up to 2025 July. That order is not there, my lord, because that petition was filed earlier. Conclusive charge sheet is put up. Since the conclusive charge sheet along with the documents in continuation of CID PS submitted by the IO against the accused Sudipto Sharma and Rajesh Bansal. So two against two, they have again Sudipto Sharma, Srimati Sudipto Sharma is the wife of Partho Bhardwaj, and Rajesh Bansal is another accused, my lord. You also will find his name in there. Moreover, IO has found no materials against accused Rasendra Bhavani Singh Thakur and prayed for releasing him in the instant case. Now, उनको भी दे दो, दोनों सीट दे दो। अरे यार, जो स्टेटमेंट का है, एविडेंस का दो ना, तुम यार सब कुछ तुमको डिफिकल्ट है। दोनों दो, दोनों पूरी सीट इनको भी दो। My lord made a query whether all the witnesses are same or not, my lord. To that and my lord, for date of examination, I'll just pinpoint this. My lord, your lordship will take first this statement of witnesses cited and relied on. There are two, my lord. One is for documents.
Which one? You have said. given two
Statement of witnesses cited.
Ah,
I have annexed the, my lord, the scan copy. My lord, I have taken permission from the court, this honorable court, and taken a certified copy, my lord. I have annexed those. My lord, you'll find, I'll go to the statement later on, my lord. Deepak Tyagi, his informant, my lord. His statement is there. He is also, in the first charge sheet, he is a witness. His statement was recorded on 10/4/2000. My lord, the dates are important, my lord. 10/4/2024. Then Anand Kumar Srivastav is witness number 2. But his, my lord, statement has not been furnished, my lord, in this year. Then Vikas Kumar, his statement, he is 3, 10/4/2024. Devraj Das, 10/4/24. Dipankar Sarkar, 4/5/24. Ratna Kalita, 4/5/24. Dhruwajit Kalita, 4/5/24. Jitu Kumar Das, 4/7/24. Rupchand Singh and Bhargav Sharma, my lord, they are documentary, statement not recorded. That is in the charge sheet itself. Then my lord, Sanjay Chauhan on 19/7/2024. First charge sheet was filed, my lord, in July. Prior to that, not cited as a witness. In our case, he is not cited as a witness, my lord, but his statement is there, my lord, I find. Then Inspector Raja Sarkar, not cited as a witness, no statement. His name is also given there. Not cited as a witness in, my lord, the first charge sheet. The Pawan Kumar Borman, he is not cited as a witness. Then Pawan Kumar Singh, he is not cited as a witness, though statement is there, my lord, in the scan copy. Now, the statement of K.R. Nagappan and Bhelappu Srivas, their statement is also, my lord, given. So that I have enclosed. Now, my lord, from here, I want to show first thing. My lord, I am not arguing on the, my lord, passing of the, my lord, charges on merit. So for 173(8) is concerned, my lord, if your lordship already read 173(8), my lord, it says that to collect new materials, my lord. If, may I take my lord to again? I'm sorry. Nothing in this subsection shall deem to preclude further investigation in respect of an offence apart after a report under section 2 has been forwarded to the magistrate, and whereupon such investigation the officer in charge of the police station obtains further evidence. Well, this is more important. I am emphasizing on that. Oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed, and the provisions of subsection 2 to 6 shall, as far as may be, apply in relation to such report or reports as they apply in relation to a report forwarded under section 2. My lord, what I am trying to, my lord, make a submission here, my lord, two aspects. First thing, my lord, he has to, my lord, find out some new. If he has taken permission, let us suppose that, my lord, he has taken a permission. Now, my lord, he investigated further. He found some new materials. Now, he has to place those materials, not to file a charge sheet against the second person. This is one aspect of the matter. Secondly, that there must be some new material to file a supplementary charge sheet. Your lordship, I have shown from the chart that I have given the statement of. The last is 19/7/2024. The first charge sheet was filed on 20th of July 2024. And the second charge sheet was filed on 13/12/2024. So, my lord, no new materials were available while filing the second charge sheet. So, this is, my lord, direct infraction of section 173(8). I have made a statement to this aspect, my lord, in para 37 to para 37 to para 41, my lord, page 35 to 39. And the documents, my lord, your lordship will find. Well, I'm not on that. I'll come to the second question, my lord, afterwards. केस लो कहाँ है? हमारा नहीं, हमारा एक अपना। My lord, 173(8) does not say that, my lord, the permission is required. It says that police has the power to, my lord, further investigate. Now, my lord, the judicial decisions Lord, I have found, my lord, I am placing before my lord, my lord. It says three things, my lord. One thing, my lord, that there must be some fresh material should be there. Secondly, permission is required. Thirdly, my lord, that trial has already begun in the first case because the charge has been framed. Witnesses were called, my lord. The further orders, my lord, I have seen, my lord, the witnesses were called, the PW1. He was called, he did not appear, my lord. On 2 occasions. My lord has rightly pointed out that there is a prayer. No doubt, my lord. My lord, I have also seen, my lord, I have marked it. There is a prayer, no doubt of it. But no order has been passed, my lord, to that. Now, my lord, these are the decisions which I find relevant. पूरी पिक्चर की कॉपी देते हमारे यहाँ नहीं देते हम उसको टॉप से दे दो बार दे दे ठीक है दे दो हमको दे दो क्या है तो कुछ छुपाना तो नहीं मैं टेक माय लॉर्ड टू दिस first decision is of 1979. Lordship will kindly see para 20 and 21. Anyone acquainted with the day-to-day working of the criminal courts will be alive to practical necessity of the police possessing the power to make further investigation and submit supplementary charge sheet. Supplement. It is in the interest of both the prosecution and the defense that the police should have such power. In case it is easy to visualize a case where fresh materials may come to light which would implicate persons not previously accused or absolved persons already accused. When it comes to the notice of the investigation that a person already accused of an offence has a good alibi, is it not the duty of his agency to investigate the genuineness of the plea of alibi and submit a report to the magistrate? After all, the investigation agency has a greater resource at its command. With a private individual, similarly, where the involvement of persons who are not already accused comes to the notice of the investigation agency cannot keep quiet and refuse to investigate a fresh information. It is their duty to investigate and submit a report to the magistrate upon the involvement of the other person. In either case, it is for the magistrate to decide upon his future course of action depending upon the state at which the case is before him. If he has already taken cognizance of the but has not proceeded with the inquiry or trial, your lordship will kindly see this is important. He may direct the issue of process to person freshly discovered to be involved and deal with all the accused in a single inquiry or trial.
But this part is he may direct.
Huh?
Yes,
This
sir.
part is he may direct. This observation is he may direct.
Yes. May direct.
He may direct.
No, he
After-
may direct, my lord, but subsequently also, my lord, your
Not
lordship will
specifically
find.
on trial, he may direct.
Trial, he may direct the process to person so and so and so. If the case of which he has already previously taken cognizance has already proceeded to some extent, he may take fresh cognizance of the offence disclosed against the newly involved accused and proceed with the case as a separate case. Now, my lord, I am skipping this part. Next, last few lines. We should not, however, be understood to say that police. My lordship got it. Last 5 lines.
Which paragraph?
उसी paragraph में last में है. We should not, however, be understood to say that police should ignore the pendency of a proceeding before a court and investigate every fresh fact that comes to the light as if no cognizance has been taken by the court of any offence. We think that in the interest of independence of the magistracy and the judiciary, in the interest of purity of the administration of criminal justice, and the interest of committee of the various agencies and institutions interested with different stages of such administration, it should ordinarily be desirable that police should inform the court and seek formal permission to make further investigation when fresh facts comes to light. Here are 21, the last 2 lines, my lord, that has been on. Where the police desired to make further investigation, the police could express their regard and respect for the court for seeking its formal permission to make further investigation.
But this case is not similarly situated here. Already police has made an observation request. You may be permitted.
No, true, my lord, I'm not that.
Assist Milords for only for a minute if permitted, Milords.
Yes, yes.
Milords, just because I wanted to simplify it, because we are going on 173. Milords, this is a very peculiar case, Milords. Milords, it's not a case there where you've brought in fresh accused, Milords. What has actually happened, Milords? When the FIR was registered, Partha was arrested. And the police was duty bound to file the charge sheet within 90 days. Otherwise, you would have got a default bail, Milords. Milords, all other accused, including the petitioner present in this court today, Milords, for quashing of the charge sheet, they were they were away, Milords. They were beyond the reach of the police. They were clothed with the protection order of this honorable court. On the first occasion, a ex parte interim order was granted, and then he was granted. Because the first, why there's a three charge sheet, two supplementary charge sheet coming, because these people, take a situation. If a charge sheet was filed without investigation, today they would have been standing here and asking the court to quash the charge sheet because no investigation has taken place. Because the first charge sheet was filed in July, the subsequent charge sheet was filed in November of the same year, 24. Only once they got the protection order from this court, anticipatory bail, the present petitioner, others anticipatory bails were dismissed, my lord. Then he appeared, the matter was investigated, he was put this question and charge sheet was filed, my lords. Because the entire argument is on 173.8, my lords. What is the purpose of, because in the rarest of rare cases, FIR can't be quashed. That was Niharika and subsequent judgment of the Apex Court. I'm totally cognizant of the fact that the court which has the power to quash a FIR has the power to quash the charge sheet. Now, what is the difference between going on discharge application and quashing of the charge sheet is primarily, Milords, we argue every day, Milords, where there is an abuse of process of law. Milords, why you come to a high court for quashing of the charge sheet? Because that abuse of process of law is not available when I argue a discharge application, Milords. Milords, the entire petition summarizes on the defense, Milords. The petitioner is this, petitioner is integrity, petitioner has not taken money, he has an alibi, he was in Hyderabad. Milord, that can't be considered, Milord, in a quashing of a charge sheet. What the petitioner needs to show, that read out those portions from the charge sheet where there is no material qua him. Milords, forget about, Milords, the FIR will be reproduced in the charge sheet, we all know. Now we are at a stage when we have to read beyond FIR. We are not on quashing of the FIR. We'll have to read that during investigation, what is the material found against all the accused. And that is precisely there in the charge sheet, Milord. That is what needs to be read, Milord. 173.8, Milord, the magistrate had all the rights, they have made the permission. They have given enough time for the accused to come and give their version, Milords. Their CDR data, Milords, what my learned friend says, that it's a verbatim. It has to be. The story can't change. If Milords two different, let's assume for a complainant also, if a second statement is recorded, they will say that there is an improvement over the previous statement. We are sticking to our complaint there and then. The other accused, as and when they appeared before the investigating agencies, they were interrogated, they were put to questions, only thereafter the charge sheet was filed. And Milords, more interestingly, this accused is not appearing before the trial court, Milords. Taking a plea that my petition is, Milords, there's no stay and trials can't be stalled. He has not even appeared once also, Milord, after the summoning order. He gets all the documents from somewhere else. God knows where.
Okay. So at this stage, plea of alibi, all these things are not to be gone into. Anything like plea of alibi or something.
No,
like
those
that,
are not defense.
character,
Those are defense, Milord.
antecedent, all these are.
I'm not arguing, Milord.
We have to accept the
Charge sheet
FIR
as
it is,
a-
as plus the charge sheet as it is.
I'm not on that.
Assuming it to be true.
So
without-
something is stated in the petition, Milord.
And
Milord,
without-
I'm not going to argue.
Cannot resort to any
No, I'm not going
material.
to argue, Milord. Plea of alibi has to be taken as a defense. No, it can't be taken as a Milord.
He has mentioned,
No, he has mentioned.
and
because
not
that is-
regarding character
that is mentioned
antecedent
in
also.
FIR, that's what.
Not
that
regarding
is
character
mentioned in the petition.
antecedent also. He may be a dreaded criminal.
Yeah.
That is a different issue. Or he may
Milords,
be-
I have not raised it at all, Milords, that point.
So as it is.
Yeah.
Now,
No,
question
they-
is regarding further investigation, your point urged. This prayer is already made, right?
Yes.
That judgment is that after court can issue direction.
Yes,
Court can issue direction,
yes, Milord.
right? Cognizance is taken of the offense,
Not
Right,
the
Not
offender.
the offender.
not the
Not
offense.
the offender, Milord. Yes, I'm aware of that, Milord. I'm aware of that.
So, para 2021, court may direct it is already expressed desire to make further investigation. So paragraph 21, last 3 lines may not be. Yes, after closure, they have already said, intended that yes, it is
Intention
not
is there, that has been shown.
complete charge
That
sheet.
has been shown.
Not complete charge sheet. Yes, had it been complete, then yes, they could have made a prayer. At least from this, it is not direct on the point. First one.
No, but I'm pressing on this.
Ah.
Let me complete it, my lord. Because so far the other party is concerned, your lordship.
Ramlal
made-
Narang, it is that I think smuggling.
Narang, I have
London,
Vinay-
smuggling to London perhaps.
Huh?
Smaller conspiracy, bigger conspiracy, perhaps. Ramlal Narang.
Yes, yes.
Some
Yes,
antique,
rightly.
antique
Yes, my lord. Antique
treasures.
Antique
That
treasure.
I
I
remember.
agree.
This
Then
is-
Vinay Tyagi, my lord.
This is smaller conspiracy, larger conspiracy.
In our case, my lord, I'm not arguing against this, my lord, the conspiracy, they have put, my lord, 120B and put everybody. My lord, I have not done anything, save and except, my lord, I was a liaising agent. That is their admitted case, my lord. Now, my lord, next case is Vinay Tyagi.
Yes,
13.5,
Tyagi.
2013 5 SCC, my lord, second page 672. The paragraphs are, my lord, I have not read the entire paragraphs. Here, my lord, all the 3 questions were considered. Further investigation,
Which paragraph?
paragraph 22, my lord, will carry them. Further investigation is where the investigation obtains further oral or documentary evidence after the final report has been filed before the court in terms of section 173(8). This power is vested with the executive. It is the continuation of previous investigation, therefore is understood and described as further. The scope of such investigation is restricted to discovery of further oral and documentary evidence. I am emphasizing on that. The last 3 lines of that paragraph, the basis is discovery of fresh evidence in continuation of the same offense and chain of events relating to the same occurrence incidental thereto. Lord, no fresh evidence has been brought, my lord, on record. Then this is fresh investigation. We are not concerned about that, my lord. Then your lordship will count. Now, page 29. Para 29. Now we come to further former question, that is whether the magistrate has jurisdiction under section 178 to direct the further investigation. Then several cases has been referred, my lord. Ultimately,
See paragraph 31.
huh?
31.
Well, this is earlier case, Mithu Bhai's case.
31, paragraph 31.
Mithu Bhai's case has been, my lord.
No, the observation.
I'll place, my lord.
Court observed that the police has the power to conduct further investigation in terms of section 173(8)
Yes, my lord.
of the code, but also opined that there are 2 situations.
Yes, my lord.
Even the trial court can direct further investigation. 2 things.
My lord, your lordship will kindly find page 40.6, my lord. Your lordship will directly find that. Your lordship will directly, those has been, my lord, in paragraph 40, that has been, my lord, yeah. After, my lord, analyzing the or.
Okay, let us see.
Para 38 is also important. However, having, my lord, may I read first 38, my lord, then I'll come to 46. However, having given our considered thought to the principles stated in these judgments, we are of the view that magistrate before whom a report is filed is empowered in law to direct further investigation and require the police to submit a further or supplementary report. A 3-judges bench of this court in Bhagwan Singh has in no uncertain terms stated the principles as aforesaid. Now, my lord, in para 46, what my lord is saying, it has been procedural or proprietary that police has to seek permission of the court to continue further investigation and file supplementary charge sheet. These are the conclusion, my lord. Yeah, that points are, the other paragraphs are not relevant for us.
No, para 41.
There are
Next
41.
page.
Yes, well,
That is
just,
what I was
just a minute.
fourth line. Two things. Further investigation conducted under the orders of the court,
Yes.
including that of the magistrate. This is one. Next, or by the police of its own accord and for valid reasons will lead to the filing of a supplementary report. So two things. One, direction for further investigation by the magistrate and the police on its own record. That is not curtailed by 173(8). But other discussion in the previous part is that when the magistrate can
No, that's
direct
true.
further investigation.
Well, it,
I think everything is concentrated on that point,
no, well, that is
not
true.
on the police on its
So far
own
the
record.
judgment is concerned, it was whether he has a power or not. Whether magistrate has it.
But here 173(8),
Yes.
which the situation which we are being faced, that police on its own record already has admitted in the first report.
No, that is true.
That can continue. See, police of its own accord and for valid reasons would lead to the filing of a supplementary report.
No, well,
No, it is evident. There are two things. And which already the police has expressed its mind that we would be continuing with the further investigation. This part is regarding magistrate directing further investigation.
Just a minute, may I just.
One can't translate into the powers of the other, my lord. That is what the essence of this. My lord, investigation is the police power, my lords. Only the constitutional courts can direct, my lords, court monitor, SITs, not the.
Reinvestigation, de novo, all these
My lord, these-
constitutional court.
Yes, my lords, not
But
the.
so far as trial court is
And then-
concerned,
Those are not higher court can give. Those are
and
not.
even higher court cannot direct how the police should investigate.
No,
Exactly,
that
Lord.
cannot direct. That cannot direct.
So-
That power is with
That
the
is
police.
the-
And it
That's
is
what
part
it
of the investigation
That's what it is.
process. Police can also say that we have completed and there is another reason maybe for default bail. Now that has everything has been stayed by Manpreet Singh or something like that, Sanwar. That
Yes,
is-
yes, my lords.
Everything is kept on in limbo. Supplementary charge sheet, all these have been kept in limbo. Everything is to be decided on the case to case basis. Is it not?
Yes, my
What
lord.
is the decision?
Pardon, my lords?
That decision after that, this regarding charge sheet, part charge sheet
Yes, my lord.
and supplementary charge sheet.
My lords, that.
Judge decision was there.
Because they've been different on different, my lords. On NDPS, they've been different, my lords, that.
No, what is
the-
that decision? Everything is kept in limbo now.
Yes, my lord, that it will not be considered an incomplete charge sheet if the FSL report is not a complete. So lot of flux, my lords, lot of flux. My lord, but Supreme Court time and again, my lords, have always said that the each one has to be respected, my lords. And the domain of investigating agency, my lords, the judiciary can't step into it, my lords. And the magistrate, that has been, unless and until, my lord, in Khaturana's case, where there was complete injustice by the investigating agencies, my lords, that they were taken out from one state to another, my lords.
Now, my lord, this decision was, my lord, two judges.
What is the decision on what point? Magistrate's direction?
Yes, my lord, the second point is Bindu Hai, my lord.
Once we read para 61, my lords, that will be make it conclusive, my lords.
Para 41 is clear. Para
61, my lords. My learned friend, the senior will read that.
My lord. In our considered view, the trial court has to consider the entire record, including both Delhi Police report filed under section 173(2), as well as the closure report filed by CBI and the documents filed along with this report. It appears the trial court may have three options. Firstly, it may accept the application of the accused for discharge. Secondly, it may direct that the trial may proceed further in accordance with law. And thirdly, it is dissatisfied of any important aspect of investigation already conducted and is considered opinion, it is just proper and necessary in the interest of justice to direct further investigation, it may do so. My lord, we are not on that, my lord. Para 61, my friend is.
No,
Referee.
no. It is basically magistrate's power to direct further investigation. Come to question number 1.
So that has,
These two are the questions considered.
yes, my lord. The second
And
question
nothing
was,
is related to us
the second question,
because
the second question has been dealt, my lord, from
that is fresh
para
investigation
29 onward.
Re-investigation.
Para 29 onward.
No, question number 1 and 2.
Ah,
These are the two questions.
my lord, which para, my lord, is referring, my lord?
In this Vivek.
Yeah. Binay Tyagi.
Binoy Tyagi.
The two questions, my lord, page 772, my lord. Page number 772. 13.5 assist. Whether in exercise of power under section 174 criminal procedure, the trial court has the jurisdiction to ignore any of the reports where there are two reports by the same or different investigating agencies in presence of the orders of a court. Or reports of the same or different investigating agencies in presence of the orders of a court. The first question was that, my lord, in this case, Delhi police file a charge sheet. Then, my lord, CBI file a charge sheet.
Totally different, my lord, out of context, my lord.
Different.
Completely out of context, my lord.
Whether the Central Bureau of Investigation is empowered to
issue-
conduct. Now, my lord, the 3 judges bench in Binu Bhai, my lord, that has been made it clear, my lord.
One minute 49.
The questions were, my lord,
1 minute.
Yeah.
Because these are big judgments.
these are big judgment, my lord. नहीं लगा कह दिया बोले सर मैंने क्या की ब्रॉड पेज आदमी अद्भुत है कोर्ट का भी चेक लगा नहीं क्यों नहीं लगा
This is everything magistrate power to direct investigation. Further
No,
investigation.
my lord, here the case was little different, but by, my lord, they have decided this point also, and 40.6 is, my lord, the
So
ultimate.
questions are framed too.
The questions are different, my lord. Question is that, my lord, there are two charge sheets. Your lordship will kindly see again, my lord.
Question number 1 and 2.
Here 1 and 2. My lord, your lordship will kindly see whether in exercise of power under section the trial court has the jurisdiction to ignore any of the reports where there are two reports by the same or different investigation in furtherance of the order of a court. That was the question, because the court's direction was there.
So here it is not the court direction.
Court direction is not there, but my lord, I am showing from that.
That is
My lord,
para
that
40,
ultimately in para
just-
40.6.
Para 41 I have read.
My lord, yes, true, my lord, your lordship has read, my lord, I have read, my lord, your lordship will kindly take, my lord, the next decision, Binu.
Yes, not laid down in the code that police should seek permission
In the-
or leave of the court, but as a matter of propriety, normally police approaches the court to file a supplementary charge sheet, but it is not a violation of the code. But as a matter of practice or
That was
convention, it generally does.
Yep.
But in violation is not result into illegality or irregularity.
True, my lord, unless and until it is mandatory, my lord, it will not violate, definitely, my lord, I'm not arguing on that. Now, my lord, I'll place Binu Bhai is important. The third decision, this is a 3 judges bench decision.
Page 1 minute. Binu Bhai.
Third
okay.
third flag. my lord. Break
Binu
lagaya hai.
Bhai. Third flag, okay.
My lord, I'll not read the entire, if you don't see it, my lord, I'll go directly to para 42, page 39, internal page,
42.
42.
Again, it is magistrate power.
My lord, yes, there is no good reason, my lord, may I read?
Para 42.
42 at page 39, internal page, my lord.
42.
There is no good reason why given by the court in this decision as to why magistrate's power to order further investigation would suddenly cease upon process being issued. As an accused appearing before the magistrate, while concomitantly the power of police to further investigate the offence continues right till the stage the trial commences. Your lordship will kindly, this is important. The stage the trial commences. This aspect, my lord, I have already pointed out. In this case, trial has already commenced. Such a view would not accord with the earlier judgments. So and so and so. Binay Tyagi has been considered, having clearly held that criminal trials does not begin after cognizance is taken, but only after charge are framed. In our case, my lord, Partha Bhardwaj charge has already framed. What is not given any importance at all in the recent judgments of this court in Article 21 of the Constitution is the fact that the article demands no less than a fair and just investigation. To say that a fair and just investigation would lead to the conclusion that the police retain the power subject, of course, of the magistrate's note under section 178 to further investigation or till charges are framed. But that the supervisory jurisdiction of the magistrate suddenly ceases midway through the pre-trial proceeding would amount to a travesty of justice, as certain midway through the pre-trial proceeding would amount to travesty of justice, as certain cases may cry out for further investigation so that an innocent person is not wrongly assigned, arraigned as an accused, or that a prima facie guilty person is not left off. There is no warrant to such narrow and restricted view of the powers of magistrate, particularly when such power are traceable to section 156 and all that. Section 173(8), as has been noticed here in above, and would be available at all stages of the progress of criminal case before trial actually commences. It would also be in the interest of justice that this power to be exercised suo motu by the magistrate himself, depending on the facts of each case. Whether further investigation should or should not be ordered is within the discretion of the learned magistrate, who will exercise such discretion on the facts of each case and in accordance with law.
These are again on the. No, this judgment again is on the magistrate's power, my lords. Nothing, my lords, all the accused have challenged that magistrate can't do this, magistrate can't do that. That is what the learned senior is reading, you know.
Here is, my lord, your lordship.
Magistrate's power
Power.
to direct further investigation extends up to what stage?
That is limited. That power is limited, my lord. That's what
That
is
power is limited. Yeah, he can do it suo motu, but that is subject to certain terms and
restrictions, my lord.
restrictions.
Your lordship will kindly see last para 42, whether last few lines, whether further investigation should or should not be ordered is within the discretion of the learned magistrate, who will exercise such jurisdiction on the facts of
That
each
is
case.
his power.
His power, that's what it says, my lord, that his permission.
There
is
may be,
anyway, my lord.
there may be other so many decisions on this point.
My lords, for
no,
supplementary
directly-
charge sheet, if this order is passed, my lords, hundreds and thousands of cases will go away, my lords.
All these PMLA,
Everything will go away.
In
Milords,
this
sir,
case-
multiple supplementary charge sheet comes as and when the accused keeps adding Milords. Milords, even in Christian
yes, do you have
Michel's.
any decision on the point?
Milords,
your
Milords, this is something very strange to me also, Milords, because what I was expecting, the quashing of the charge sheet will come on abuse of process of law, Milords. Or
No,
there
but-
is no material call. But I never knew that the entire argument will be on 173.8, Milords.
My lord, the next case, my lord, that directly that on that
Let,
point.
let me find out.
My lord, yes, lord,
Just
we
a
will
minute, just
definitely
a minute.
read, my lord, I am not saying.
No, just a minute. No, I
My lord,
want to know
ultimately, my
also.
lord, it's a,
No,
my
no,
lord,
ultimately, I want to know
yes, my lord,
so
ultimately,
that
it's a process, my lord. Where we also learn.
because the decisions basically on substantially on the point, the magistrate's power to direct further investigation
And to what
And-
extent?
and to up to what stage, what restrictions, but not specifically on the point that when police or investigating agency has sought leave to continue with further investigation, whether that power can be curtailed.
Very
There
rightly
is a-
said, Milords. Very, absolutely. It's a.
Subject to what your
Yeah.
lordship says,
No, no.
my reading, my lord, is that, my lord, they,
Because
though your lordship
I
is.
want to know also.
Ah.
I want to know also.
No, no, definitely, definitely. Okay.
If you have a point on that,
Yeah.
then it will be very welcome
So
because.
because, my lord, I have argued basically 173, 3 points.
Ah,
3 points is that, my lord, no new material has been found out. Because for second charge sheet, your lordship will can see 173.8 says, and that is the mandate I have shown. Secondly, trial has already begun. In this Binu Bhai's case, para 42 also says, that till the charge sheet, till the charges are not framed.
So I have posed one query.
Yes,
When the police has sought leave of the court
yes,
to continue with the investigation process and to file a supplementary charge sheet.
yes,
Okay, subject to you, what you said, further material.
yes, true.
Right? Whether that power can be curtailed.
My lord, the power cannot be curtailed. 178,
and
the
to,
power cannot be
when-
curtailed.
When thereafter submits a supplementary charge sheet,
Correct.
right? Whether that can be examined, that no, you cannot file charge sheet, supplementary charge sheet, right? Because we have already started the trial.
Yes,
So far these decisions are concerned,
yes,
it is the magistrate's power or the trial court's power to direct further
true, my
investigation
lord.
under 173(8) CRPC. Not directly on the point that if police submits a supplementary charge sheet
True.
against few other
Other
accused,
persons, my lord, yes.
whether the magistrate's or trial court's power is curtailed not to take cognizance
my
of
lord,
the
your lord.
offense.
Narang's case is very clear, and the Binu Bhai's
Narang
case-
is, no,
Narang's
Narang
case
is,
is very clear,
if I
Binu Bhai's
remember
case is very
correctly,
clear.
some antique pieces,
Let us,
smaller conspiracy and larger conspiracy.
let us assume, my lord, for time being, my lord, as your
If
lordship
you
is saying,
see,
my lord,
if
that
you see, if I remember correctly, because I once argued on Ramlal. Ramlal is page.
there are two conspiracies, my lord, had not is there.
No, this some antique
Yes, yes, my lord,
pieces, London,
I remember.
London Museum,
But your lordship will kindly see that.
smuggling, two brothers, Narang brothers perhaps.
Narang brothers.
Is it not? But there are many other international conspiracy. So this is on that point.
No, my lord, what I am trying to point out from Narayan, that once, my lord, charge is filed, cognizance is taken and charge is framed, trial begins, my lord. Then the, my lord, my lord, magistrate cannot accept the charge sheet and, my lord, take cognizance of the second charge sheet. And that is also in Binu Bhai, your lordship, para 42 is very clear on that.
Narang is regarding two FIRs. Smaller second.
No, no, I have read para 20, my lord.
No, I have read the earlier and
Ah.
entire judgment. Two brothers involved in smuggling, two charge sheets, two FIRs, then said permissible. The conspirators were different. Initially two brothers, then thereafter international smugglers came in.
Somebody joined me.
So
Some other.
smaller conspiracy, larger conspiracy.
Some.
First FIR, second FIR, first search sheet, second search sheet.
Milord,
Permissible.
very classic, just remember. Milord, in Augusta Westland helicopter case, Milord, the charge sheet were filed in 2014 against Gautam Khaitan, all those lawyers, Milord, corporate law
I
firm
haven't
lawyers.
read that.
And Milord, Christian Michel was brought to India in 2019, Milords. And supplementary charge sheet, Coahem was filed.
Okay, and
I
what is the next one? Next one?
42, my lord,
What?
which I am referring to para 42. My lord,
42.
42 I have read it, my lord. The Binu Bhai case.
Binu Bhai.
My lord, it will be line about 14th line to say that a fair and just investigation. My lord, got it, my lord. 14th line about.
Which para?
Para 42. Binu Bhai. To say
Ordered,
that
this is ordered again.
lead to conclusion that.
I marked.
Huh?
Whether further investigation should or should not be ordered. Is within the
Till the
discretion.
last offense till the charge is framed. Charges are framed.
So I have put the query for you to answer.
Well, my answer is that, my lord, the second charge sheet, in view of this, my lord, cannot be taken into consideration. So in Narang case, it says that you file some another charge sheet in different case, my lord.
No, Lara is
Anyway, my lord,
that is a completely different context.
in that also it says that
One, is there any head note?
yeah, here also 173 8 CRPC as been noticed here in above would be available at all stages of the progressive criminal process before trial.
Right. See second line itself.
Which where, my lord?
No.
Two. On Narang.
Subsequently, genuine pillars were
No,
found in the warehouse in London.
I have read, my lord. I have.
So, as a result of conspiracy between Narang brothers, Malik and Mehra, the fake pillars. So, few more, and that was a different conspiracy altogether.
My lord, I am on not facts, my lord. My lord, I am just showing my
No,
law.
Facts decides the.
No, true.
Rest
Facts
you.
decide the law. But 42 is squarely applicable in my case. Then, my lord, the subsequent decision.
What is the fourth decision?
This is Pithambaram. In this, my lord, I'll directly go to first para 28, my lord. Then, if need be, I'll take your lordship to other paragraph. My lord, para 28. Here the DSP.
Para?
Para 28, my lord. That is the conclusion. In terms of second question, the above second question is.
Let us see the question first.
Yes. There are questions, my lord. Your lordship will find.
Please on record.
क्वेश्चन कहाँ है देखो तो
Some reinvestigation.
Reinvestigation is a different thing, my lord. We are not.
No.
Reinvestigation has
First
to be.
three para indicates different issues.
It has been discussed from, my lord, para 17 onwards in this case. But I have not found, my lord, subject to correction, the questions. Must be there.
No, para 9.
Yes. Or the second question, that whether the district Kottayam order was permissible in law or not, the relevant provision of CRPC is read as under.
Again, the same issue.
Same issue, but, my lord, para
Order
28.
of the magistrate.
Para 28, my lord, will kindly see.
Whether 1 minute. There are 28.
There are 19 and 20 are important.
19?
19, 19 and 20. Well, the facts are there. The chief police officer of a district is the superintendent police, who is an officer of region so and so. Needless to state that an order from the district police chief is not the same as an order issued by the magistrate concerned. Referring to Vinay Tyagi and Devendranath so and so noted that there is no specific requirement to seek. That was the argument, my lord. There was no specific requirement to seek leave of the court for further investigation or to file a supplementary report, but the investigation has not only understood it to be so, what have to also adopted the same as a legal requirement. The doctrine of so and so contemporaneous expositio adds such an interpretation of matters which has been long understood and implemented in a particular manner to accepted in the interpretative process. In other words, the requirement of permission for further investigation or to file a supplementary report is accepted within the law and therefore required to be complied with. In the facts of the hand, it is clear that such a permission was never taken, granted, or ordered. Consequently, FR2 is without basis. FR1, it has been stated that in absence of any document in respect of the financial transaction, the instant case may be treated as false case. This then would necessarily imply that after due investigation conducted by a duly authorized person, the conclusion is that the ingredients of the section mentioned in the FR has not been met and no case is made out. Then we have two cases that these are not relevant for our purpose.
Milord, Niharika's judgment is quoted, which is relevant for us, Milords.
Which
Niharika judgment will all
No,
come later.
Milords, what it says, Milord, the essence of it, Milords, in the same way, in the same breath which my learned friend has senior has argued, Milords, Milords, it's paragraph 23, Milords, same
Yeah.
judgment.
Yeah. Niharika, my lord, I don't find anything with regard to 173(8).
Milord, none of the judgment says
No,
that.
here initially final report was submitted with a closure
Yeah.
report. It is a false case. Then the police, the
But
district
police chief ordered.
police chief ordered for investigation. Then charge sheet was submitted. This is the fact is different.
That-
Once closure report is submitted, then
Milord,
definitely you
where
have
is the
to seek a
judgment which says
permission.
that if there is a supplementary charge sheet, the entire,
The whole scenario has been changed. Initially, it is
Facts
a
are that. Facts are.
false case. Then suddenly
Yes.
district police chief ordered for investigation. Then finding a privacy case and charge sheet has been submitted.
there
In
are-
that context, these
there
observations
have
are
been many
made.
cases where Supreme Court has come and says, okay, no, this entire investigation is reinvestigate.
So
Take it
last-
to a
let-
different-
Let me play the last case, my lord, and then
Mhm.
I'll conclude.
Mariam.
This basically para 38, 39 is with regard to, my lord, further materials collected.
Which judgment?
This last, Mariam. Para 38, page
38?
740, 38, 39.
3839.
Questions overlooked by the lower courts. This is the heading.
Again, magistrate order.
Huh? No, I am not on magistrate order.
No, no,
Yes.
the case is on the after magistrate order. Para 37.
Para 37.
Para 37, last line. Last
Trial
court-
court order.
accordingly,
dated
no charge
24
sheet was filed under those provisions. However, in compliance with the trial magistrate's order dated so and so, a supplementary charge sheet was submitted.
That's-
Same magistrate order, all are magistrate order. We are trying for the exact legal proposition on the police already seeking permission to continue with the,
I have not found, my lord, if your lordship, my friend can.
to cut the matter short, otherwise we have found on these 5 cases, magistrate's direction or trial court's direction to either to file a charge sheet or to continue with the investigation or to
That's where Supreme Court has intervened, my
Ah,
lords.
so
Not in a case where police says
subtle-
that we,
subtle difference between the two situations. So definitely there are authorities.
here the accused were not
Ask-
available for investigation that time.
The last decision, that is para 38 and 39 is, my lord, on different subjects. Last flag, 5. Or para 39 is more important. It is a matter of record, 38. In course of further investigation, no material was unearthed by the investigation. Instead, the supplementary charge sheet relies on the truth slave report so and so, which was already available when the original charge sheet was filed. The term further investigation is stipulated in section obligates the officer in charge of the police station concerned to obtain further investigation, oral or documentary, and only then forward a supplementary report regarding such evidence in the prescribed form. The provisions for submitting supplementary report infers that fresh oral or documentary evidence should be obtained rather than re-evaluating or reassessing the materials already collected and considered by the investigating agency while submitting the initial report known as charge sheet under section 1. In absence of new evidence found to be to substantiate the conclusions drawn by the investigation in the supplementary report, a judicial magistrate is not compelled to take cognizance. As such, a report lacks investigative rigor and fails to satisfy the requisite under section 173. What becomes apparent from the facts on record that this is a case of investigating agency acted mechanically in purported compliance with the trial court's order.
Lords, I put a question to myself, my lords. My lords,
My lord,
the entire investigation has to be qua the accused, my lords. Lords, those accused making themselves available for investigation, isn't that a new material, my lords, before the court in a supplementary charge sheet? My lord, what my learned friend says, the entire story remains same. Yes, it has to remain same. Only once these two accused come and explain and give their version, give their statement, isn't that a fresh evidence? That was not available to the investigating agency when they filed the first charge sheet. It is only upon investigation that they found their versions, their statements, which they included and filed a supplementary charge sheet. What else would be a fresh material, my lords? My lord, this is not a murder case where in the first charge sheet you don't file it without the murder weapon and in the second you do. So you explain them.
No, that's not new. Yes, 39 is to an extent.
My lord?
39 to an extent
Yes, yes.
is in accord with your submission.
And that is the my lord,
But yes, but at the
176.
same time, court make it clear that investigating agency acted mechanically pursuant to for compliance of the trial court magistrate's order.
No, that's true. Here, your trial court's order is not there. But the
Okay.
second charge sheet has to be within the mandate of section 173A.
CRPC has traveled for about 60 years. There
Yeah,
must
my lord.
be a decision on this point, which I have pointed out.
Then I have to make search.
If you can show it, otherwise I have to find it out, fish it out.
No, I'll definitely find
Lords,
out.
I'm not going into the
My lord,
petition,
not
my
your-
lords.
not
The
your lordship.
petition is complete
Yes.
defense, my lords. I'm not wasting my lords' time.
Yes, your outstation council,
Yes, my lords.
huh?
Yes, my lords.
You're from?
Delhi, my lords.
Okay. Is there anything, something to contra?
My lords, if I go to the,
No, on the point, on this point.
on 173, no, my lords.
Second, two issues, if I have found that police on its own accord can continue the investigation in view of subsection 8 of section 173. As has been pointed out somewhere already. And secondly, it is the power of the trial magistrate or the discretion to direct further investigation. Two ways. 173(8) does not debar
No,
the police.
that's not it.
But as a legal practice,
Yes, it has to be.
sometime, but it is already clear in the last part of the search sheet that we are continuing with the.
They have
may be
stated,
permitted.
they have stated.
Right.
They have stated.
There was no specific order of rejection
Ah.
that don't do.
No rejection, no allow,
rejection, no accord approval.
no rejection also.
They have submitted the charge sheet. Initial charge sheet, 1. Second charge sheet added 2 more accused.
My lords, they were
Equally-
there in the FIR, my lords. It is not that someone from outside has been brought in. Yes, my lords.
I have read that.
Yes, my lords.
Then third charge sheet, 2 more. So in 5 or 6, finally, with
Five,
3,
six.
1 charge sheet, 2 supplementary charge sheet makes the charge sheet process complete.
This is
Right. Now question is, my query is that all these decisions are rendered on the whether as regards the power of the magistrate or trial court to direct further investigation. Right. And there it is, the trial court should not exercise such power after the trial has begun.
Yeah.
Right?
That's true.
On that point, I am clear now. But so far as the first thing
The
that,
first point, my lord, is not satisfied.
not satisfied.
True.
If not satisfied, that if I say that Mr. Agarwal or senior counsel has failed to bring any direction, then 173 goes by it.
So what, my lord?
No record, not required.
On two other.
First, we will go by the statute. Second, by the decisions of Supreme Court and High Court. Right? By the statute, there is no bar.
No bar.
So you have to point out. Otherwise, there must be authorities on it. Secondly, that same thing up to what stage?
And then
Supplementary charge sheet.
two other questions.
Supplementary charge sheet can be, if in the first situation,
Yes.
police can file supplementary charge sheet. Up to what stage of the proceeding? Up to the, say, cognizance, or up to the framing of charge, or any period beyond it.
Well, the
There may be an issue. After framing of charge, supplementary charge sheet is issued, and police goes on filing charge sheet, adding new. That this is not a fair trial. It will not be a fair trial for the first accused,
okay.
right? Because he again, charge will be framed, again he will face, this cannot go on, for him at least. This has to be curtailed, that part, because number one accused is that
Partha.
Partha. Charge is framed. Suppose 3 witnesses have been examined, then police files a charge sheet. Then again 2 more added, right? Again PW 1 to 3 again will be examined, re-examined, cross-examined by all. That cannot go on,
Yes, my lord, sir.
right? Then again another will be filed. Again 2 more. Again all the witnesses will be recalled. Somebody will exercise their power to re-cross-examine again. That cannot go on. But there has to be something laid down norms.
So for the two other things are concerned, subject to your lordship's consideration, my lord. The lordship says that so far the magistrate's power, it is not, it is a procedural. As because of this decision says that it's a procedural, there is no decision that if the magistrate's power, order is not taken, it will be not taken into consideration. There is no such decision that I will show you. Well, the second question is that up to the state of, my lord, framing charges, they can file. Not beyond that has been already settled here. Secondly, that, my lord, face material, if they have not brought, the second charge.
No, that question is laced with the first condition, that magistrate should not direct further investigation after framing of charge. There are two situations. One, police power to continue with further investigation. Second situation is magistrate directing further investigation.
And we are in the first situation, my lord.
We are in the first.
So we leave aside the second situation, my lord.
Leave aside.
And
Let
then
us
find answers for
put
this.
it directly on the first,
Okay.
so that you can assist the court, because these decisions I am not, because every decision is the decision on its own facts.
Yes, true, my lord.
So,
It's not a straitjacket formula. It can't be.
so by an interpretative process, cannot be said directly that the first situation can be comprehended in the second situation. That is all. That part has to
Okay,
be answered
I'll try to-
in clear manner.
Yes, my lord, yes.
Then we'll see up to what stage magistrate can accept a supplementary
Yeah.
charge sheet.
Milords,
And whether-
I
and whether-
fully agree with, and I, Milords, bow down to what Milords is saying, very fair, Milords. Milords, let the, Milords may record that both of us will assist, Milords, on this point. It's
Yes.
no longer our client's case. It's, we are more of the officer of the court, Milords.
Yes.
And in such a situation, with both of us exchanging our notes, not hiding from each other, so that we can
nothing
assist
to
the
hide.
court in the most,
Nothing to hide.
in the beneficial way.
Yes.
Let me go back, Milords, put my team on research, and we will share the notes with my learned senior.
And senior counsel assisted by Mr.
D. Rathi.
Rakhi, learned counsel for the
Very
petition, Mr.
Vikas Gupta.
Vikas Gupta.
and Sohil Sharma.
Learned Counsel is led by Mr.
Sohil Sharma.
Along with Mr.
Sohil Sharma,
Shohil Sharma, Learned Counsel for the respondent.
number 2.
Oh, your private counsel. Where is? Yes, Miss. You are the main person.
Yes, yes.
Two persons are arguing, you are keeping silence. You are the main person to assist the court. You are silent.
Yes, yes, my lord. Ultimately, my lord, he is
He is the
informant.
first
Lord,
officer of the court.
Prosecution is led by her, my lord.
Ah,
The
they may have
definition
special
of victim
interest,
has been enlarged.
but you are the officer.
Ah, yes,
Yeah.
sir.
They may have some more interest, private interest. But you are the person, officer of the court. Also heard Ms. S.H. Boral, and additional public prosecutor for the respondent number 1 state. Police. The from the submissions, must be learning counsel for the parties. An issue as regards power of police to continue in the investigation further investigation of the case under section 173(8) CRPC after submission of a part charge sheet against an accused is permissible, and if in the affirmative, comma, a supplementary charge sheet against more accused can be submitted up to what stage of the criminal proceedings? Up to what stage of the criminal proceedings?
Lords, can we have the order, Dusty, my lord, so that we comply with completely what my lords, what's fallen
Yes.
from my lords?
Okay. A copy of this order as requested
My lord,
is to be supplied to the learned counsel for the parties.
So that we comply with my lords.
Next
what-
week,
9th, I am suggesting, my lord.
lest I forget.
9th, I am suggesting.
My lords will not forget because I was
Because
there a
From
couple of months
16
back.
onwards, probably, my lord, I have some difficulty. I will be away, my lord.
Okay, find out a convenient date.
9th, my lord, my.
Maybe next 2,
Huh?
3,
Fifth, no?
maybe I may be there for next 2, 3 weeks.
Pardon, my lords?
At least I may be there, not to forget.
My lords, then
Next.
we'll go by that, my lords.
Say up to 20, any date is convenient. 20th February 20.
February, my lord, from 16th, my lord, I have some difficulty. Prior to that, my lord, probably your lordship may fix also.
Mr.
13th also,
He
my
may
lord,
have
12th,
difficulty.
12th.
10th is fine.
Huh?
10th February.
हाँ 10th होगा 10th होगा.
My lords, 10th. My lords, 10th February.
Not 10th,
Yes, my lords.
someday else. So I have kept 2 other matters on 10th and 12th.
My lords,
11 अपना दिखाया है हम लोग.
Mr. Agarwal, you have difficulty up to what date?
12
My lord, I'll be, my lord, up to the, yeah. I'll be available again, my lord, from 2nd of March, my lord. But 2nd is open, 3rd and 4th is holiday. It will be too longer for me, your lordship will forget.
No.
It's all right. So can it be, my lord, then, my lord, my learned friend agrees, let it be 6th of March.
yes, my lords, I have no difficulty.
Okay.
6th of March or 6th of March.
Is on 6th of March.
My lord, I have one difficulty here, my lord.
6, no, 5th is better.
Ah,
5th is better. my lords.
Thursday.
My lords, 5th
I
is
have
better,
a-
my lords.
fifth
Fifth,
is better.
even
My
for
lord,
me,
I
my
have,
lord.
I have one prayer, my lord. The matter is fixed on 25th of February for appearance.
You have been seeking time on this ground only.
Manage yourself the way they have been doing it, my lords. That's what we do for all the other accused also. They know the best
Is there
way.
any,
My lord, 5th of March, my lords.
1 minute.
I have a hearing matter also.
There might be decisions on this point.
Yes, my lord, definitely, my lord, it will come.
Not a point not traveled.
My lord, it's my fault. I was not prepared. I mean, I was on the.
I'll place all the decisions. Well.
Yes, my lord.
I have found some decisions. I'll place all the decisions.
Because best
Better-
part is,
better- better
because
the-
rather than just reading few lines out of in a judgment, that's not the right way. We'll have to see in what context it is written, what are the facts of the case. Just reading two lines that magistrate doesn't have the power or police doesn't.
No, it
Not bring it, my lord. Then that's the reason I
it will
couldn't.
be too risky.
Yes, my lord, we can't, and I didn't have the time to go through the judgment because the facts of the case speak something else. What has been just as a passing remark has been said by the court, my lords. So it's in, and in none of the cases there's a clear-cut judgment that a supplementary charge sheet it goes away. There's no such judgment.
No.
So it is all pointing towards the mandate or the powers of the magistrate rather than anything else. They're more over talking of the separation of powers, my lords.
I have seen another judgment.
And because that is going on in the.
Start of evidence, recording evidence may not be a bar.
Yes, my lords.
Recording of evidence.
Even start examination of witnesses.
My lords, we've seen
It's
in
already
multiple.
started. May not be a bar for filing of
Second charge sheet.
My lords, in Vyapan case,
supplementary.
in Vyapan, my lords, it went on for years together and supplementary charge sheets were added as and when fresh material came out, my lords.
But-
In Madhya Pradesh, my lords.
But there are situations when suppose you have already filed a charge sheet, then you have to seek a permission for further investigation. There are myriad situations.
And my lords, in this case, it
But
is
we
not
have to
that,
stick by
it
this.
is not that somebody from the street has been picked up. Those
One point is
accused-
there, last judgment, that IO is not permitted to go through the same material and to file a supplementary
yes,
charge
yes,
sheet.
that's
That
it.
observation is there, last case.
Yes.
You know, in this case, the accused did not make themselves available for investigation. And a situation arises now.
You
if-
make submission after taking into account that decision.
Yes, my lord. I'm highly grateful.
Yes.
I have a hearing.
That I was according priority to that case only. When did you?
It will be already 3:30. Other matters are there.
Day after, are you available day after tomorrow?
Day after
If
tomorrow
Mr.
will be-
Kotogi is available.
Day after, I have little difficulty is there. That's what I'm saying. Day after tomorrow. Can it be then, my lord, on 10th? 10th, my lord, if your lordship is. Or 10th, you have lordship fixed already 2 matters.
I have some other cases.
This week, little difficulty.
This Thursday, this Thursday. Possible.
May not be, my lord.
29th of January. Today is 27.
I have understood, my lord, the difficulty.
Or 3rd of February. This is 2009 matter.
Then it will be better, not 3rd of February, then my lord, better be, my lord, 29th, my lord.
29.
If your lordship insists, then my lord, I have to be, my lord,
Ah.
on little safeguard because other matters are already fixed, my lord. I have to.
The list, item number 9. List the case 20.
But can it be, my lord, at 2 p.m., my lord, if your lordship?
On this 29 January. In the top of list, the case will be taken up at 2.
That will be, my lord. My problem will be solved.
Item 11.
Well, please, your lordship. It's an application under 4528, was seeking questioning of the proceedings by the petitioners. Now, before we go into the case, would like to submit the petitioners, who are these petitioners basically, and how they are related with the informant. The petitioner number 1, he is the husband, the nephew. Petitioner number 2 is the husband. 3 is the mother-in-law, and 4.
1 minute.
Your Honor.
Let me go to the list of petitioners.
Yes.
Huh.
Petitioner number 1 is the nephew of the informant, the complainant. Petitioner number 2 is the husband. 3 is the mother-in-law, and 4 is the sister-in-law. Now, what has happened is that this particular affair was transpired on the heat of the moment. And now she has realized of the fact that maybe due to some other outside influences, she may have approached the police station regarding a matrimonial dispute. If we go through the contents of the FIR, it only comes out a matrimonial dispute. And then later on, what has happened is that the police have taken the, recorded the statement of the minor child of the complainant. And in the particular statement, maybe some sort of materials or some sort of statements may be divulged from the victim child,
Let
which
let me have the opportunity of
Yes.
reading the FIR first,
Yes.
then I
Page-
can, I can.
page number
appreciate your
18, my
submission.
lord. Page number 18, my lord. My lord, that FIR is page number 18, my lord. Annexary. Annexure 18 and the contents is 21, page number 21. That is the contents of the FIR. May I read, my lord, if I'm permitted?
I'm reading it.
Oblige.
IPC BNS চাওঁ আৰু JJ খন চাওঁ JJ খন This 85 is 498A.
Yes, my lord.
Yes.
85 BNS is 490 day. My lord has gone through the FIR.
1 minute.
Oh, my lord.
পক্সোখন চাওঁ পক্সোখন Yes.
Yes. Now, my lord, I would like to take you to page number 35. That is annexure D. An affidavit.
No, it was investigation.
Yes, investigation has been done. Charge sheet has also been filed.
Just-
And now this case is pending before the special judge POXO as session special case 111 of 2025, which is arising out of the All Women's Police Station 45 of 2024. Now, my lord, now I want to take you to page number 35. That is the affidavit, which has been signed by the informant and now has been given to the petitioner, saying that she does not want to proceed further. The main reason behind is that she has accepted herself and admitted that maybe due to some misunderstanding, she may have filed this FIR against her husband along with all the family members. Now, if permitted, may I read the contents of the affidavit? My lord, page number 35, para 3, my lord.
1 minute. Where are the statements of these two?
The lower court record was called for on last occasion.
So. So far 498A is concerned, no doubt about it.
My lord.
But what to do with the statement of,
My lord, that is why we want to basically rely on this.
So far the statement is concerned, my lord, it is.
See.
Yes. That is why, my lord,
the child is concerned.
Yes.
Not only 161,
Yes.
164 as well.
Yes, absolutely. Now the fact is that, Lordship, that's why by going through this affidavit, which has been signed subsequent to the filing of the FI, that is, this affidavit has been signed. We have got the original copy here. The informant is also appearing.
Informant, your lordship.
Is
Lordship,
for the
the FIR was arises out of a matrimonial dispute, your lordship. So now for the
So
sake of
whether
the,
that third statement can be erased out of the record.
lordship is correct.
Huh?
Lordship, pardon.
That statement
Yes, yes.
of the child can be erased out of the record.
No, lordship.
Huh?
My lord,
So far as one accused is concerned.
Understand, lordship. Lordship, now we are living peacefully with my husband, so.
Right, that I know. So address on
Yes,
because,
absolutely.
because that aspect cannot be ignored.
Right, right.
Maybe, I don't know, we cannot go into that fact that whether she was tutored or not tutored.
absolutely.
Lordship
We
is
cannot
correct.
Absolutely.
go into that, but we cannot at the
But-
same time ignore.
Considering the fact that now they're living under the same roof, since filing of the FIR, they're living under the same roof in the same house.
Yes, I know. I have
Absolutely.
watched
Lordship is correct.
at least 100 proceedings.
Yes,
Correct.
my lord is totally apprised.
But this fact can be ignored.
And regarding the medical report also during the
That-
charge
that
sheet,
against at least one petition.
my lord, now only we have to go with the presumption of the guilt in under 29 and 30. If we go to the statement, other than that, there has to be some medical evidence. If it is there, then it will also corroborate. I do not think so that they are
Minister,
relying on
medical, we are not going into that aspect. We are not into trial.
Yes, yes, absolutely.
But question is regarding power of this court under 482.
So we would like to, I would like to cite a case.
So far as
This one, Gyan Singh,
Yes.
Lordship.
Dhyan Singh is not under POXO. Don't say Dhyan Singh or Lakshmi Narayan up to Lakshmi Narayan. Show me on POXO.
My lord. We have,
POXO section 12, 4-year-old child. Show me.
my lord, we have
I am ready.
annexed coordinate bench judgment order passed by this honorable court in one of the similar cases. It is not, the facts may be different, but one coordinate bench has passed a judgment on questioning the proceedings on the merit that we cannot directly go into the aspect that the only.
This is regarding marriage of 16, 17-year-old.
Yes,
That
yes.
I know.
Now regarding
That
the,
I know. Show me 164 statement.
my lord,
Even that
we
mother can condone.
absolutely.
Mother can condone.
Now the fact the family is living happily, both the
No, then
husband and wife, they have settled their
trial should die a natural death.
absolutely completely private in nature. This offense,
Right. But POXO is not private.
Absolutely, my lord. That is
POXO is not
I-
private.
yes.
498A may be inside, but POXO is against the entire gender.
my lord. If we go with the statement
That
164,
There is no
164,
authority that it is private.
my lord. If we go with the statement 164, also there we see actually. I have not annexed the copy, but I have gone through it. There it is. Ketia Marisil Moi Nazanu. There was she didn't knew also.
Don't expect more.
Yes,
Don't expect more.
absolutely, my lord.
Huh? From a 4-year-old girl child.
Yes, see that is why also that because she is quite minor. So
It should die a natural death,
Yes.
the trial. Unless it will be set as a precedent.
the accused one, he is a student, my lord.
Right.
nephew
It
also.
should both, as soon as the receipt of summons, both the witness should appear, then I don't know.
Now summons have been served to them and as such.
Otherwise,
court
if
has-
I observe something,
No, sure.
trial court will be in difficulty.
My lord, the inherent powers are with the mind.
That inherent power will
Yes.
be exercised for dismissing the petition. So in that case, it will be difficult. I had indicated you enough.
My lord,
Because
considering the
these-
fact
no, POXO for, I cannot
that
ignore.
12 up to 3 years, my lord, the
No, that is not the issue. Even your attempt to murder can be,
my lord.
offense can be done if it is not on the vital part of the body, not on the head or leg. Yes, it can be quashed. That is law is settled. 498A, okay. 406, 420, all okay. But not murder or
My lord.
other offense.
Yes, my lord, absolutely. It
This
is,
is
it
not-
is very unfortunate that if something has,
An investigation, FIR is not encyclopedia.
yes, that is true. Now going through the charge sheet and relying on the documents,
No, sir. Sorry.
my lord, only 4 witnesses are there.
That is,
Uh,
Mr. Mehdi, I had
my lord.
indicated.
Yes, my lord. My lord is very much has taken it into consideration.
But for me, it is difficult. That statement cannot be ignored. Had it been only 161 before police, it could have been ignored,
My lord,
right?
my lord,
But it is before a magistrate also.
my lord. Now only in the evidence stage we we have to go and see if it happens. The testimony.
I had indicated to you,
Yes, my lord.
better not to invite any comment from this court.
My lord. My,
You are living happily
yes.
once you appear. Because only 4 witnesses.
Yes, my lord.
3 is in your favor.
Yeah, yeah,
IO cannot do anything.
absolutely, my.
I have seen
Yeah.
list of witnesses.
Yes, list of witnesses.
So better to not to invite any comment.
My lord, however, my lord looks into it and considers it.
Show me any POXO case can be.
I will request sometime if one day is given. One more.
Okay. Day after tomorrow.
I will search into it. Yes, I will do my.
Is the case. You'll not find any.
Yes, yes. Like, we'll just maybe in the meantime.
Had it been a lady got married and a birth child, date of a child in the meantime living happily with her husband, 16, 17 years, yes.
Yes, exactly.
Supreme Court has passed,
Yes,
but not in respect of
India
3, 4 years
Supreme
child.
Court has said it, madam, but not here, madam.
Okay, W.R. Medhi, petitioner, Mr.
R. Yasin, Lordship.
Ari,
R. Yasin.
for the respond number 2.
Respond number 2, Your Lordship.
Okay, and Mr. M.P. Gustani.
Yes.
Please the case on behalf of more.
20.
Find out.
29. Just for, can it be on 30th? 30th? 30.
Okay.
Oh. Oblige.
Yes, sir.
Well, this application has been filed under section 528 of the BNSS, my lord. So, my lord, second party has appeared, my lord. Service is complete, they have
May I
appeared.
please, your lordship? Lordship, I am appearing for respondent number 2, lordship. We have filed our wakalatnama recently. Some time may be granted, lordship.
Some time may be granted.
Lordship, matter may be taken Friday,
Okay.
lordship.
Mr.
I don't know what to propose.
S.R. Bovia,
Yes, my lord.
learned counsel for the petition
My lord, matter may be fixed after 6th of February, my lord.
Respect.
It is, my lord.
on the prayer and Mr. M.P. Goswami are present, huh? On the prayer of Ms.
S.R. Majar Bhuya.
S.R. Major Bhiyan, learned counsel for the respondent number 2, comma, has agreed to by the learned counsel for the other side. This is the case on so and so. Interim order.
11?
Interim order
2.
passed, shall
Yes.
continue till the next.
Yes, my lord.
Oblige.
Interim order passed again. Oblige.
Please, Your Honor, kindly pass over the matter for time being. My senior is on legs.
What timing? Some other didn't. On the request of Mr. Miss so and so. You are there?
I am but respond number 1 and 2.
Okay. You have entered appearance.
Yes.
65B,
Yes, Lord.
you have challenged that. Okay. After some time. You are ready?
Ready.
May I please, Lordship? Lordship has taken the matter on the last occasion, my lord.
Problem may be, your lordship, it will be difficult to conclude today because
Yes,
I have to
yes.
refer to those judgments and all. my lord. Some other.
Other matter took time.
Yes, my lord. May I pray, my lord, subject to your lordship's convenience.
Lordship,
Right.
next date is fixed on 6th of February.
No, no,
on the
no,
trial
you are not being summoned. I have also told on the last occasion. It is fixed tomorrow. We'll take time, my lord.
on 6th of February.
No,
For
sixth
every
time,
day.
not yes, six.
The 6th of February. 6th of February.
Third of February.
No, no, your lordship, may I pray, my lord? If it is fixed on sixth, but I will be out, my lord, your lordship, subject to your lordship, on 11th of February. They will not be disturbed, my lord.
Okay, Mr.
Hey, how are you, my lord?
For the petitioner.
11.
Mr. MP Goswami. Now, additional public prosecutor for the respondent number 1, State of Assam, and Mr. B.D. Code and his senior counsel, estate by Mr. P. Dole.
That's it.
Legal counsel for the respondent number 2 are present as fought for and agreed to by the learned counsel for the parties. List the case on which date you want?
11.
11-2.
Yes, ma'am.
11-2. Yes, Mr. Sinha.
Yes, my lord, here we have challenged the proceeding, my lord,
Proceeding of what?
criminal proceeding, my lord.
Or offense? Offense?
And the offense, my lord, the cognizance your lordship will find at page
Trial court record. Scanned copy. Proceeding drawn. Complaint case or FIR?
No, FIR, man.
The house.
Index. Page 43 and exit 7.
Huh? FIR is?
FIR is at page 27.
27.
26 is the English version, madam.
26. Came into vehicle. What wrong with that?
Yes, my lord. If
What
we
is
go through that 161 statements, my lord, no
What is that?
such materials comes out, my lord, whatever the section.
Oh, record is it?
Well, it has come, my lord, but I have not checked the record. Let it, my lord.
Can copy also.
Cognizance নিছে না?
Cognizance আছে.
Perhaps not there. See for yourself whether they are available. You appeared in your trial court.
Yes, my lord, we have appeared. We are on bail now.
Not here, man. The party is not here. Only the charge sheet is there.
The informant.
1 minute, 1 minute.
CD part will be required now. Who does charge sheet from us? Only charge sheet is there.
Statement to animal statement. Statement to like.
Page 48.
Yes.
Informant's daughter.
Yes, my lord.
Leave the case before me.
Informant daughter.
Let the.
Leave the case before me, sir.
Yes.
Not before me.
No.
Item 15 for orders.
Alright.
She was associated with me when she was in the profession.
Yes.
Alright.
Suspension of sentence and bail, my lord. 376, 10 years.
Taken. Initially, steps not taken.
The steps taken, my lord, on 19 December, prior to vacation, but.
No step for notice.
No,
You have entered. Respondent number 2. Issue notice, can copy TCR.
so my lord, so far.
Mr. A. Paul, learned counsel for the petitioner, and Mr. MP Goswami, learned additional public prosecutor. For the respondent number 1, state of some are present.
My lord,
Present, Mr. Ann Gogoi, learned counsel, has submitted that he has entered appearance on behalf of the respondent number 2 by filing Wakalatnama.
my lord, so far as the,
Today.
my lord,
Post of.
may I please something? Well, this is the issue of petitioner approached this honorable court only for the limited pair, only for suspension of the NBW issued by the learned trial court. That is the limited issue, not other issues involved. So, lordship, on 30 trial court date, I am ready to appear. Kindly that impugned order may suspend,
Okay.
and I am ready to appear.
Release the case tomorrow. In the admission column.
Item 19.
Please, there is a counter affidavit, my lord. While is a counter affidavit, my
You
lord.
should notice, for what,
A
for what
counter
purpose?
fire, my lord.
Neither ID card, no, service not complete. Received from,
Therefore,
TCR received,
taken-
TCR received. AJRTL, learned counsel for the petitioner, Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, state of Assam are present. TCR has been received. Pays the office note dated 21/1/2026. I wait for a service report in respect of the respondent number 2, release the case on so and so.
The interim order in the meantime. Interim order.
32.
Is there?
Pair 9 to लिखी दियो. Open.
Interim.
Open. Interim order, let's open for consideration.
Time being matter, item 13.
Keep open for consideration, we can do. Agora pair 9. Yes.
May I please, Your Lordship? Application under section 528 of the BNS Lordship for quashing of order dated 22/11/2024, passed in NI case number 137 of 16. Now, Lordship, in this, the basic facts which arise in this case is that the complainant brought in the witness of a bank witness before the Learned Trial Court. And this is a proceeding under section 130 of the Negotiable Instrument Act. Now, during the cross-examination of the said bank witnesses, it was admitted by the bank witness that since he had not submitted the 65B certificate, which has to be brought along, filed along with the electronic documents he brought along. So his documents are unadmissible as evidence for in the said case. Now, thereafter, Lordship, on that day, the evidence was closed. And on the next date fixed, Lordship, that is on 22/11/24, no, sorry, Lordship, the next date fixed, they filed an application under 3/11, Lordship, for re-examining the said witness and bringing on record the 65B certificate. Now thereafter, the said application was allowed by the learned trial court. So Lordship, we are here on the basis of that provision, Lordship, that
Same position has been reiterated time and again, right from Arjun Pandit or something like that.
Lordship,
Right from Arjun Pandit, this E Nasir, there are subsequent decisions also. On 65B.
2023.
There, so many new decisions also, any stage. And this is not a thing that which is to be, what is the subject?
138 of the Negotiable Instrument Act. 138 of the Negotiable Instruments Act, Lordship.
Use today's part necessary for, who filed a petition? Complainant.
Lordship.
311.
Lordship.
Bank manager came, deposed. Statement of account. (65B) by recalling PW2.
A subsequent instruction, Lordship, I got is that subsequent to filing of this case, since initially there was no interim protection operating, what happened, the complainant had filed the 65B certificate, and what comes out of the perusal of the said document, it seems that that has been filed not by the witness who was again paid for recalling, but filed by another witness on the guise that the other previous witness has been transferred.
And it can be because, no, now which ground you are urging?
Lordship, we are
Which ground you are urging?
we
That is
have-
not the ground urged.
No, that
Well,
this is a subsequent development, Lordship.
that you may raise, that is a different issue.
Lordship.
You will get ample
T Nasir is clear. T Nasir, Arjun Pandit. And it has explained that 65B certificate is not going to prejudice the accused.
Lordship.
The accused will have full opportunity to rebut the evidence.
Lordship.
This is 2023, that is Najib, no?
T. Nasir, Lordship.
T. Nasir.
Paragraph 10, 11, 12, 14.
আৰু আছে নেকি? আৰু আছে নেকি? 65B. This good annual case. Okay, paragraph 10.
Paragraph 10. Said that.
Another decision, no?
That's all. 19.
Curable defect.
Curable defect. Paragraph 11 or 6, it has stated that it can be produced at any stage.
And (15).
12, 14 and 15. Paragraph. It was produced after a gap of 6 years.
Ten is clear. If an objection is made,
Lordship,
then the prosecution is to be given an opportunity to rectify the deficiency.
Lordship. But Lordship, on a perusal of the order gives a blanket recall of the witness, Lordship.
No,
There is-
only point the point of 165B, is it not?
Lord,
Accordingly, a prayer is made for recalling the PW2 along with the appropriate certificate in support of Exhibit 23 as required under Section 65B of the Indian Evidence Act. That is page 22, last line.
Lordship.
Last line, only that to that extent. Then your ground is trying to fill up the lacuna, which has
Lordship.
been discarded by the Supreme Court already.
Lordship.
That this is not lacuna, it is maybe a mere curable defect.
Lordship.
I don't think you have anything.
Lordship.
Regarding another
Lordship.
person that you urge,
But
you will contest.
but at least, Lordship, that the direction that it should be only to the extent of the 65B.
We'll only observe that only.
Yes, Your Lordship.
Yes. Heard Mr. M.K. Das, learned counsel for the petitioner. Mr. D. Kolita and Mr. D. Kolita, learned counsel for the respond number 1 and 2. Stop. This criminal petition under section 528. Bharatiya Nyaya Sanhita 2023 is preferred to assail an order dated 22/11/2022 passed by the Court of Learned
CJM.
Subdivisional Judicial Magistrate S. Tinshukia. Trial court for short in NI case number 137/2016. By the order dated 22/11/2024, the trial court has allowed the complainant side to recall and re-examine one prosecution witness, PW2 within bracket Prakash Singh,
Prashant Kumar Singh.
Prashant Kumar Singh, branch manager, Punjab National Bank, bracket close, for producing a certificate as required under 65 capital B of the Indian Evidence Act 1872, full stop, para. The respondents hearing as complainants have instituted a complaint case before the trial court alleging commission of an offense under Section 138 Negotiable Instrument Act 1881 as amended, wherein the petitioner has been arraigned as the accused. Full stop. The complaint case has been registered and numbered as NI case number 137/2016. Full stop. In a complaint, it has been alleged that two checks for amounts of rupees 4 lakh and 2 lakh respectively were issued by the accused in favor of the complainants from account, from a bank account maintained by the accused with in Maligaon Sariali branch, Guwahati of HDFC Bank Limited towards partial discharge of liability. Full stop. The complainant has alleged, complainants have alleged that when the checks were presented for collection, they were returned unpaid on the grounds of insufficient fund.
Yes, Your Lordship.
Full stop. The complainants have asserted that they have followed the requisite formalities to institute the complaint. Full stop. Para. After taking cognizance of the offense, the trial court issued process against the petitioner as an accused in connection with NI case number so and so. Upon receipt of process, the petitioner entered his appearance after he denied the acquisition when explained by the trial court, the complaint side had, at first submitted evidence on affidavit of the complainant number 1 as PW1.
PW1, Lordship.
Post of. After closure of evidence of the PW1, after cross-examination, the second prosecution witness, PW2, was summoned. PW2 from the whose bank?
Punjab National Bank, Lordship.
From Punjab National Bank. Tinshukia, where the checks were presented for collection.
Lordship.
Was called to adduce evidence. Full stop. The PWP was done. Okay? The PW2 was examined and cross-examined on which date?
Lordship.
19/6/2024. And thereafter he was discharged. Full stop. Para. Subsequently on 18/7/2024, my petition was filed by the complainant side before the trial court for permitting for recall and re-examination of PW2 as on 19/6/2022, when PW2 produce the statement of account. The same was not accompanied by a certificate under section 65 capital B of the Evidence Act 1872. Hello, buddy. Full stop. The petition was numbered as petition number 2959/2024. Full stop. The trial court, after hearing the parties on petition on the point raised in petition number 2959/2024, had allowed the prayer for recall and re-examination of PW2 within bracket Prashant Kumar Singh, branch manager, Punjab National Bank, for production of the certificates under section 65B of the Evidence Act 1872. Full stop. Aggrieved by and dissatisfied with the order dated 22/11/2024. The petitioner who is the accused in NI case number so and so has preferred this with petition. Sorry,
Not
criminal petition. Criminal petition. Raising, essentially, the ground that if the complaint side is allowed by recall and re-examination of PW2 to produce any certificate under 65B Evidence Act, the same would amount to filling up the lacuna in the complainant's case. Full stop. It is the contention of the learned counsel for the petitioner that power under section 311 CRPC is only to be exercised for just decision of the case. And in the event of non-production of a certificate under section 65B Evidence Act by any witness, such a witness cannot be recalled and re-examination for the purpose of enabling him to produce the certificate under section 65B Evidence Act. First stop. Para, this I have gone through the order dated 22/11/2024 passed by the trial court, wherein the trial court has assigned a regions for exercising the power under section 311 CRPC. Full stop. In order to decide petition number 2959/2024, the trial court has found that the if PW2 is allowed to be recalled and re-examined for the purpose of producing a certificate under section 65B Evidence Act in support of the statement of accounts he had already exhibited during his testimony, would not amount to filling up any lacuna, full stop, in the complainant's case, full stop. Here, the trial court has further referred to the decision of the Honorable Supreme Court in State of Karnataka versus
T. Nasi.
T Nasir Elias কি লাগি বহুত আছে Umar Haji so and so. Rendered in special leave petition criminal number 6548/2022 post. Para.
Para 15 as per the order, Lordship.
Evidence account put. Section 65B of the Evidence Act pertains to admissibility of electronic records. Full stop. As per subsection 4, subsection 4 of section 65D has inter alia prescribed for a certificate. If a party desires to give a statement in evidence regarding electronic records and such certificate, is can be issued for the following things, ABC. First of para. In state of Karnataka versus MR Hidemat 2019 9/7 SCC 515, the Honorable Supreme Court has held that non-production of a certificate under section 65B of the Indian Evidence Act is a curable defect. Full stop. It has referred to a decision in Sonu versus State of Haryana 2017 8 SCC 570, wherein it has been observed that the crucial test is whether the defect would have been cured at the stage of marking the document. No, not again. So the to observe from the decision in Sonu versus State of Haryana 2017 8 SCC 570, it can be noticed that if an objection regarding the crucial aspect which is to be looked into by the court while exercising her discretion under section 311 CRPC. Is that it has to exercise the discretion after seeing that the accused is not prejudiced by the want of a fair trial, and the court may, in appropriate cases, can allow, in appropriate cases, allow the prosecution to produce such certificate at a later point of time. Full stop. In a subsequent decision, State of Karnataka has said, the Supreme Court has observed as under paragraph 15. In view of the above proposition, in view of such settled position, wherein the accused would have the opportunity to rebut the evidence laid by the prosecution, even after production of a certificate under Section 65D Evidence Act, with a recall and re-examination of PW2, this petition, criminal petition, assailing the order dated 22/11/2024, passed by the trial court in NI case number so and so, is found to be bereft of any merit, and the same, and consequently the same is dismissed. So you challenge the other aspects.
Lordship, an observation that only on the part of the production of the 65B certificate. That your Lordship may kindly.
It is only that petition I have said.
Yes, Your Lordship.
If they traverse beyond that, you have the power to object.
Lordship.
Why should we observe?
Lordship.
Let them do it.
And another, Lordship, I apologize, another correction, Lordship. One check was dishonored because of check stop instruction, and one check because of funds insufficient.
Okay. One is?
Check stop instruction.
Okay.
And one is funds insufficient.
Very good. Fund insufficient stroke. Check stop from payment. Okay?
Instruction.
Hearing. What is this?
In item number 22, my lord, I am for the respondent, my lord.
No.
In this matter, my lord, the learned counsel for the petition, either concurrence findings against my lord, he is sure to pay the regarding the that compensation amount, my lord, after 1 month. It has not been paid. It is more than 1 year past. So some urgency, my lord, first week of February, any date, I leave it up to lordship.
21. We are more concerned with 21. 21. Who is there?
I'm for 22.
You are in 22.
Yes.
Court is more interested in 21. These are commercial dispute. 21. Who represents the appellant in 21? This is 376. And year is 2014. More than 10 years. Yes, Ms. Bora. M.A. Sheikh. M.A. Sheikh. So, hello. We'll go by the year, Mr. Dekar. This is the difficulty, Mr. Gustami and Ms. Bora. Appellant is not represented today. And this is appeal. We have to engage some amicus. Okay, we'll observe today. Thereafter, on Monday, we'll appoint amicus. There is no representation on behalf of the appellant today, despite call. full stop. On the previous date of listing, comma, 18/12/2015, comma, also, the appellant was not represented, full stop. Mr. MP Goswami, learned additional public prosecutor for the respondent state, or SH Bora, learned additional public prosecutor for the respondent state, and Mr. Ayu Choudhury, learned counsel for the respondent number 2 are present, full stop. List the case on Monday corridor.
2nd February.
Full stop. It is observed that in the event, none appears to represent the appellant on that day, the court would consider about for appointment of an amicus curiae to represent the appellant. This is appeal against conviction or acquittal? Huh? Not fair. Ziminal appeal number. Huh? 2003 appeal. Hakim. Monwar Hussain. Delivers. Appeal against acquittal. Whether it is to be heard on merit. Against conviction, I know. Yes, Mr. Choudhury. You are accused. You have been acquitted. He is acquitted. Against acquittal. How? Yes, Mr. Deka.
Number 22, my lord.
Can it be dismissed for default? Find out in the meantime. Appeal against conviction, one has to appoint an amicus. But appeal against acquittal. If there is decision, I need not have to, all you have to be spared of your time. We need not have to go through all the evidence. Find out, come back with judgment, I'll close it. If it is permitted. Appeal. No, appeal against conviction, all these decisions are against to appoint an amicus in case of appeal against conviction. Right. If here is a case appeal against acquittal, the appellant may not be interested. Then why court will waste its time to reverse an acquittal where it is very limited? Why should we, if 15, 20 witnesses are there, why should we do the all exercise? Instead of that, we can hear 2 more, 3 more matters or one more appeal. Yes,
Yes, my lord. Item number 22, my lord.
Mr. Borbuya is there.
Yes, my lord. My lord, I'm praying for the.
He is the man who is to get the amount. M. Borbuya.
Yes, my lord.
No sons.
My my lord.
Concurrent finding.
Yes, my lord.
Concurrent finding.
Yes, my
Yes,
lord.
my lord. No, my lord. Yeah,
6
my
months
lord.
conviction, my lord.
My lord, another development is there. My petitioner, my lord, is selling, my lord, some land, my lord. It is in the stage of permission, my lord. Now government is very tight in granting permission, my lord. He is willing to, my lord, settle that
That
matter.
cannot be a ground.
Yes, my lord.
You borrow,
Yes, my lord. Only, my lord, another.
thereafter repay the,
Yes, my lord.
issue a check again.
Yes, my lord.
You borrow from
So they-
Mr. X and you issue a check.
Yes.
Thereafter, proceeding will go on for next 10 years.
Yes.
He, my lord,
thought?
money.
You are
given-
clever man.
my lord, interest, my lord, money, interest.
You
matter.
decide
He,
in the
he-
meantime.
He gives the
Otherwise,
money on interest.
no, otherwise you'll go in jail.
Yes, sir,
If your
definitely.
revision is dismissed.
Scope is limited, my lord, but he took, my lord, money on interest.
Whatever, we are
Yes,
not
sir.
going into that now.
Yes,
If
sir.
you want to pay him
Yes, my lord.
by 28th February.
My lord. My lord. Before 28, my lord, we will come with, my lord, with my lord, memorandum of understanding, my lord.
Pay to his satisfaction,
Yes, my lord.
right? Otherwise, we'll take up on 1st of March. 2nd of March.
As per, my lord, they are, my lord, understanding, my lord, they will.
Whatever, it is
Yes,
not
sir.
for me. Otherwise, you'll go on.
Yes, sir, definitely.
Third, Mr. A.M. Borbunia, learned counsel for the petitioner, and Mr. P.K. Decker, learned counsel for the respondent. Full stop. This, criminal revision petition is preferred by the petitioner against his conviction for an offense under Section 138 Negotiable Instrument Act. Full stop. The trial court had convicted the petitioner, and thereafter, the appellate court has affirmed the judgment and order of conviction and sentence. Full stop. Mr. Borbunia submitted that if a month's time is afforded, the petitioner would make best endeavor to arrive at a settlement with the petitioner.
Respondent.
Respondent. Full
Right.
stop. He has sought time till 28 to 2026. Leaves the case on 2nd March 2000.
My lord.
2nd March.
Deep lord.
Our agreed amount 5 lakhs of.
That I don't
Yes,
know.
yes.
It's up to you.
My lord, item 23, I only pray for a date, my lord. This is appeal against conviction. Petitioner is behind bar, my lord.
All 2025.
My lord, but he has spent already 1 year, 3 months in jail. Sentence is for 5 years, my lord.
Okay, to deliver 23 to release the case on Swens.
Item number 24 is also he is convicted under section 10 of.
Everybody has to wait, sir. There is no shortcut. Item number
24.
24. Huh.
Not been given the relevant papers.
Okay. Mr.
KK Henry Lordship.
Learned counsel for the appellant is present. Mr. T. Dewey, learned amicus curiae, appointed to represent respondent number 2, is to be supplied the necessary case papers within 2 weeks from today by the registry. Full stop. List the case on so and so.
So I is also not been disposed of in this case.
And I have given a fixed.
24
date. We'll try.
24 to.
24.
With respect to item number 25, your lordship, there is a stay order of and the petitioner in the case. That may be extended. That's my only. The last item.
Okay, due to paucity of time, the case could not be taken up today. List the case on so and so date, the interim order past, I guess, will continue till the next date of listing.
I'm very grateful.